Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po, service Latino. I didn't ask you to interrupt.
Is that correct?
Literally not true.
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you all here this morning. We can get everything working. Had to wear blue because I wore red yesterday. And don't think I wore blue the day before that. So trying to represent all sides equally on this day three of the Dwayne Davis trial. That's going to start later this afternoon. We've got a late start this morning in that court. Wow, that is just hot. Mic is just so loud today. All right, there we go. Okay. Big shout out to Clever Name. Clever Name, congratulations. You are first in chat today. Well, for all intents and purposes, you're first in chat today, and everything IP-related worldwide is your responsibility. This is a first-time offense for you. But ignorance of the law does not make you exempt from the punishment. Everything IP-related is your responsibility. Good job, and good riddance. All right, good to have you here. I see the mods are here. Welcome, even the verbose one. Hello, Red. Good to have you here. I saw that. Troy, Amber. Let's see. Troy, Amber, Red. Greeners in the house. Yeah. Where's Josh? Is Josh just laying low this morning? He's hiding. He'll join us later, I think. All right. Good morning. How's everybody doing? It is exciting to be here. We're working our way into this Tupac trial, and I'm loving it. I do have to warn you that today obviously is going to be a short day in court, meaning we don't start until 4 o'clock. Well, never mind. It's 4 p.m. Is that right? Man, that's crazy. They don't start court in Las Vegas until 1 p.m. Las Vegas time, which is 4 p.m. Eastern time. They start when we should be done. But anyway, that's one thing to be aware of. So when people come in and ask, just make sure they know that we'll be starting the Tupac trial late in the afternoon. We've got a thumbnail up for that already. And they also need to know one other thing, and that is that...
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Oh, it just wasn't there. I tried. It's tied. 3 up, 3 down. So, ouch. Yeah, that one hurt. I knew it as soon as I just had a little catch in my throat this morning. I knew we just wouldn't have a stellar performance. Let's see. Checking the checklist. What do we need to do? Go live. Yes, check. Put chat on screen. Done. Reset counter. We'll put that to a 0. Well, it went to 90 instead. 0. There we go. Hopefully the counter will catch up here in just a minute. Say hi, everybody. Welcome. Recognize first in chat. Did that. Clever Name. That's you. Message from Mike. Message from Mike. What's that? I got 6 myself, but if you want to give me more waters, I'll put them over here. Yeah, my son is delivering water. Muchos gracias. He's learning Spanish. I'm running out of place on my shelf to put water. I'm not sure if the shelf can hold much more. There we go. Okay. Okay, we're loaded for 2 days. All right, he's learning Spanish, but he speaks it with English sentence structures. And so it's no one who speaks Spanish can understand him. Birthdays in court. Let's see. Happy birthday to Rick. There's birthdays. Oh, Mike. I get it. It's hump day. Okay, thank you for the. It took a minute for me to get it. What day is it, Mike? All right, let's do birthdays, and then we're getting ready to go to court. So when I say let's do birthdays, I mean we. That's all of us, not the royal we, but all of us, everyone together. Wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. That was so much better than the hump day yell. I think the song will go okay. There we go. Happy birthday to Rick today. Happy birthday to you. Happy birthday to you. Happy birthday, dear Rick. Happy birthday to you. Rick, you may stand alone today for the birthday song, but we're all with you. And I realize there are a million places you could be and a billion people you could have been with, but you chose to be right here with us. The privilege, pleasure, honor, joy, that's ours. Hopefully we can turn that right back to you and make your day more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Sandy's Grill, Bob Evans, and Cracker Barrel. There we go. The music was a little loud, too. Everything's just a little bit loud this morning. Let's see. Let the dancers do their thing. Go, Rick. It's your birthday. Why is my camera looking at the ground? It's not that kind of show, people. It's not that kind of show. I need to tighten the mount. It's on a swivel and it just... At least I wasn't staring at the wall. It could have been worse. Spin, turn, kick, cha-cha-cha. Yeah, got it. You guys are doing a great job. Drum solo for the big finish. If everyone wants to help me with that one. All right, welcome. It is good to have you here. We're going to go to Judge Dad first as we what? Happy birthday, Nick the Hat. Happy birthday. Nick, have a happy birthday. Consider yourself sung to. Happy birthday to you. That's all we got time for. I'm sorry. We have to go to court, Nick. We got to go to court. We also need to get you on the list a little earlier, but Nick, good to have you here. If you are, I'm just looking. I'm lurking. I missed it. It's somewhere. Rick and Nick, happy birthday today. Red Pen, we'll catch you later. Y'all be good. You be good as well. We'll see you. Nick, that's all you get. I'm sorry, Nick. Appreciate you being here. Judge Dad is also working today. Let's see what he's doing. Nope, that's not Judge Dad. This is where Judge Dad wants to be.
Thank you. Everett. William Cullen Everett. 26W843 625A and B. And Alexis Daniels, you can have a seat at the table there.
Line them up. Stack
your
them
name, please.
William Everett, Your Honor.
What are we doing on this one, counsel? Your appearance?
Michael A. Cartman, P73824, on behalf of the defendant. He's going to plead guilty to a discharge of no ops, responsible to no privilege.
Is that right, sir?
Yes, sir.
You plead to no ops. Possible penalties are up to 100 fines.
Fines are what?
90 days jail, costs are all those. And if you plead on the no insurance, that's a 0-point civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that?
Yes.
All right, to the charge, no valid operator's license on your person. How do you plead?
Yes.
On July 5 of 26 at 3:30 in the morning, were you operating a motor vehicle on Hallmere West in Woodhaven?
Yes.
Did you have a valid license with you on your person?
No.
Are you on probation or parole?
No.
Anybody forced to plead guilty?
No, Your Honor.
Please,
I'm sorry, who's that?
the plea is accepted. To the charge, no insurance. You plead responsible.
Yes.
He still doesn't have a valid license.
You should have fixed that, sir.
Correct, Your Honor. He has a couple of outstanding tickets to take care of.
You go take care of
touch with those courts.
Yeah, you gotta
warrants?
take care of those, and then you can get a license.
Yes.
Okay?
He says, I'm
Does he have
driving right over to
insurance
the other
now?
court right now.
Yes, Your Honor.
Have you seen it, Mr. Carmen?
He did not present proof, but he told me he has it. This is-
Let me see it.
Well, I have the insurance in the car. I'm about to go.
Where's he at?
He's outside. It's in the car.
Oh, you can go get it?
Yes.
Okay. I'll take you at your word. Anything else?
Thank you, Your Honor, and I believe that's it.
On the no ops, 100 fines, 150 costs, 75 victims' rights, $50 justice assessment, 375 or 60 days. And he doesn't, let's see. I'll reduce your fines on the no insurance to 100, okay?
Nice. That was a
You
big
can't be
one.
driving without insurance though, okay? You got 475 to pay. Does he have all this?
Your Honor, he wouldn't need some time on it because he just started a new job.
Do you have any money at all today?
No, Your Honor. I just went back to work. I work for a school, so
What do you do?
I'm a bus aide.
Can you pay $50 per
Drive
week?
buses.
Could you give me a few weeks to start it?
Yeah,
Yeah. Yes, sir.
50 per week starting on September the 21st. How's that?
That's perfect. Thank you.
And then I'm going to just give you on the other charge, Lisa, just have him pay the 50 per week on the civil infraction after he's done the other one.
Yeah, I can
okay?
link them together.
That's what we're going to do for you. If you need more time, you don't have the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Just don't ignore me, okay?
Yes.
Good luck. Thank you.
Thank you, Your Honor.
Alexis Chantenay Daniels, 267842984A and B.
Sounds like traffic as well.
Your
Shakes
name,
hands
ma'am?
with the lawyer.
Alexis Daniels.
Michael A. Carmen, P73824. I'm head of the defender.
All right, you're working on getting a valid license though, right, ma'am?
Yes.
All right, so I can give you a couple weeks and trust that you'll have everything taken care of?
Yes, I just gotta come back next week for our Trenton case, and then
For your what?
ticket in Trenton.
Oh, I see.
Yeah.
We doing September 2, Lisa?
Yes, at
Yeah.
9:30.
At 9:30, okay?
Yes.
September 2nd, 9:30. You can go down the hall, get your new notice, and we'll resolve it then. Okay, thank you. People against Cameron Joseph Ross. This is 26W843633. 26W843649. 23W 26W843638. These are Judge Hess's. What are you doing, Mr. Ross? You want a jury trial and a no trailer plate?
Yes, Your Honor. I tried to speak with the prosecutor on it to get it reduced from misdemeanor.
He said he offered you. He says defendant has rejected officer 2 public nuisance tickets total. Give me the prosecutor.
Prosecutor wouldn't reduce it on a trailer plate
And it
issue?
says prosecutor will make no offer on date of trial, and prosecutor They set civil infractions on, looks like same day.
Did you get in a fight with the prosecutor or something? Did you get mouthy with them, call them names?
Did I say I was taking these, Lisa?
Yeah, there's a note in here that says possible global resolution. Judge McNally to take all cases.
All right.
Well, God bless me for agreeing to do that and going to a jury trial on a trailer plate. Really?
Really?
I'd love to reach a resolution. I tried to talk to the gentleman.
Well, did you not have it? I mean, I'm going to try. I don't want to cause you to incriminate yourself. Let me talk to the prosecutor. He said he offered you 2 public nuisance tickets. That's civil infractions. That's not a misdemeanor.
Understand that. There's some of those tickets are duplicates, some of them are wrong. I'd love to see some of them dismissed. I don't think that
He's got, hang on, slow down. Let me just check this out. You got a prohibited parking.
You've just been parking all over the place with no trailer plate?
You got 2 prohibited parking tickets. Your name?
William York on behalf of the city. What name?
You got a no trailer plate.
We're going to go to jury trial.
So in essence, Judge, there's 4 civil infractions and 2 misdemeanors in Mr. Ross's name, not the corporate name.
Yeah, so he's got 6 tickets?
Correct.
And you're offering to have him plead the 2?
We're offering to decriminalize the 2 misdemeanors to public nuisance and dismiss the balance of the civil infractions. He indicated that was not acceptable.
Dude, jury's going to find you guilty. Look at the judge's face. It's a good deal.
Do you understand what his defense is?
I'm sorry, Judge.
If you want a jury trial, I'll give you a jury trial.
Your Honor.
You want a jury trial? I'll give you a jury trial.
I tried
It's
to.
the United States. You have the right to a jury trial. Thank God we live in this country. We don't live in some foreign land where judges are kings and the judicial system is corrupt. You want a jury trial? Give me a jury trial.
Give us a jury trial.
I mean, these seem pretty cut and dry to me. I mean, either the police are lying under oath by charging somebody with no trailer and some of these other things.
He's hoping for juror notification.
You just want to go to a jury trial. You want to have fun. It's okay. If you want to have fun, we'll have fun. I'm good with having fun. I like to have fun. I like to have fun. I enjoy fun. It makes me laugh, right? I want to have laughter in my life. So I can sit here and watch you try a jury trial, and it's the guy who's been practicing law for
37 years.
37 years. And we can have fun. Let's have fun. What day are we going to do the jury trial?
It'll go viral.
Can I make a statement, Your Honor?
Yeah, you can make a statement if you want. If you want to have a jury trial, though, I don't want you to think I'm stopping. Wait. I don't want you to think I'm stopping you from having a jury trial. We want to have jury trials. Love jury trials, especially in the summer, right?
Yeah.
Fridays in the summer, I want to sit in jury trial for no trailer plate. But I'm good with it because that's part of what I have to do sometimes. This is my job and I love it. I think this is silly.
Me too.
Well, then why in the world aren't you taking the offer?
I'll tell you, Your Honor. I tried to have a conversation, a reasonable civil conversation with the prosecutor about my defenses. He proceeded to scream at me and raise his voice.
You didn't scream at him, did you?
He screamed at me.
I raised my voice, Judge, because frankly, CNC and/or this gentleman have been here multiple times. Multiple neighbors have called the department multiple times. Our department has dumped a significant amount of resources into one problem. And he's entitled to a jury trial. This young man appears to be emotionally or otherwise compelled to walk right up to the line and maybe spin over it. The people have bent as far as they can bend without breaking. My law office has a client. It is the people of the city of Woodhaven. And there's nothing particularly special about someone who's running a business out of the city of Woodhaven that's frankly not necessarily even zoned for that. But frankly, it's gotten to a boiling point. Sergeant Van was here. Code enforcement was here.
Van?
Yes.
Van's a reasonable guy.
We had a discussion.
Dean Van's a reasonable guy. You're talking about Officer Van.
Yes, sir.
The one that retired from Lincoln Park.
Yes, sir.
The one that had the dog assigned to him for the longest time.
The handler, Bruno.
Reasonable guy. And I agree with you. Nobody should be treated better than anybody else. If I was doing what he was allegedly doing wrong, I'd expect you to write me a ticket. President of the United States or the mayor or the council people were doing that, I'd expect you to, officers to write them a ticket. So if you want to have your jury trial, we'll have fun. I'm telling you, fun is fun. There's nothing unfun about fun. You know what I'm saying? So if you feel that strongly that you didn't have an illegal trailer plate, and that's the issue here, go to trial. You have the right to a trial. If you think you didn't fail to change your address, let's go to trial on all of these informal hearings. We can have them the same day. You have the right to a lawyer. I don't know how you're going to win the trial when you're not a lawyer, just like I'm not going to win as mechanic of the year when I'm not a licensed mechanic or anything else. I mean, I'm not going to get in that contest. I finished 190th out of 189, but you know what I'm doing in here, and he knows what he's doing in here. If you want to have a jury trial, you can prepare your instructions, your proposed instructions, you can brush up on the evidence rule. That'll only take you
couple of years,
2 years. I mean, I've spent years studying those evidence.
I'd like to have a lawyer. I'd be retaining a lawyer for that if we go that route.
You can retain a lawyer. Did he have an invalid trailer plate?
I'm sorry, Judge?
Did he not have a trailer plate?
Correct.
Then what am I missing? I gotta be missing.
Your Honor, I had just...
Hang on a second. Hang on.
Don't incriminate
yourself. Is there some exception that allows you to not have a trailer plate on something because you just bought it? I don't know. Is there? Do you know?
Negative, Your Honor.
I didn't know. I wasn't sure. I've only been doing this for 43 years, so there's always something to learn. So he thinks, according to you, that he just is kind of above the law, is what you're telling me. He thinks he cannot have a trailer plate and expect special treatment. He must not know me for sure.
Let's do a trial.
Yeah, let's get this going. Let's move this on. We want to have a jury. How long is it going to take you to get a lawyer?
I should have one by the end of the week, probably.
Good. We'll adjourn this to September 2nd, Lisa, please. And I expect you to have a lawyer here. If you don't have a lawyer here, well, then we'll just go to jury trial without him.
Sure.
Because you can afford your own lawyer, right?
Yes, Your Honor.
Just like you could have afforded a trailer plate, right?
That's 2
weeks.
Yes,
Your Honor.
Okay. So I want to get this straight.
We can follow this one.
You offered him 2 civil infractions.
Yes, Your Honor. I offered him 2 public nuisance legal infractions.
Shame on you. Shame on you. Sounds like it's cut and dry to me, unless I'm missing something.
There's a lot more behind the story, Your Honor. There's way more than just the trailer plate ticket there. There's a bunch of tickets there. It's not just that.
And you think you're not responsible with those?
Or at least some of them.
Okay, which ones? We can talk about the civil infractions. Okay, we shouldn't talk about the misdemeanors because you have the right to remain silent, and that carries a jail term with it, possible jail term, and I can't be talking to you about that. Which of these civil infractions do you think you're not responsible of? Let me just check them out. We got a no trailer plate. We got a failure to change address. That's a civil infraction.
His lawyers
we
can
got
talk sense.
Parking a truck or trailer on the street. That's a misdemeanor. And then we've got prohibited parking and another prohibited parking and another prohibited parking. So you got 3 prohibited parkings.
Looks like
you
a
got 2
pattern of
misdemeanors. You got a failure to change address. that is a civil infraction.
Can we start with the failure to change address, Your Honor?
Yeah, you can start whatever you want. If you want, I thought you wanted a lawyer, though. I don't want to start.
I don't need one for that one. I'd just like to make a statement, and then I think, whatever it is after that, so be it. But it was before you earlier this morning under CNC contracting for the same charge that I just paid for through the company. The ticket was issued duplicate. Only one of them can be right because the address that the company is listed under is proper. My personal address was at a different address. The vehicle was registered to that address. I think that's what this ticket is for. That would mean the one that I just.
Well, I don't know whose vehicle whose name the vehicle was titled under. Was it titled in the company's name or your name?
Mine.
Well, I mean, it's very simple. Either you change your address with the Secretary of State or you didn't.
Right.
You two should be able to figure that one out.
He wouldn't talk to me about it, Your Honor.
Your Honor, as a point of order, having indicated to the defendant that the people were willing to dismiss all of the civil infractions and reduce the two crimes to civil infractions, I didn't know it as being productive to circle back to formal matters, hearings that we already pled on this morning. Some of these matters were written in the corporate name because they have that factual basis. Others of them were written in his name. He seems to believe he's being victimized. I can only tell the court what I already previously indicated, which is a raft of complaints continue to come in regarding commercial truck activity and parking in that region. The people have made a very reasonable offer. If it would avoid bringing in 35 to 50 taxpayers to sit in an array for most of the day to get picked for a jury and then try a case for the next 2 or 3 days, since Mr. Cameron appears intent on complicating the matter, that's fine. If it would be in any form productive to try to avoid that, the people would leave the amount of the fines on the public nuisance tickets entirely up to the bench, if that matter were resolved.
So what do you want to do? You want me to adjourn this so you can get a lawyer?
If we could settle it, I don't want to take it to trial. I don't want to complicate it. I just want it to be.
Did you hear what he just offered you?
Yes, that is fine. That's fine. That's fine.
Fine what? Does that mean you're taking the deal?
I don't want to be accused of talking you into anything. I could care less what you do. I want to have fun. I'm going to have fun if I take your plea. I'm going to have fun if we go to a jury trial.
We're going to have a lot of fun at a jury trial.
Affirmative, John.
I like to laugh. I like to have fun. I like to watch people that try cases, especially lawyers, because you're not a lawyer, but you could get a lawyer and I could watch it, and then it's easy for me. I just sit up here and make simple rulings. They got to do all the work.
Right.
You got to pay all the money. The taxpayers are paying them the money.
And we have fun.
I'm just sitting here. Why don't you guys go sit down and see if you can't resolve this, okay?
Thank you, Judge.
Thank you. I'm going to hand you back all the files. I'm going to take a 5-minute recess, and we will go from there. Thank you.
Wow.
Stay seated, everybody.
On that note, those two men are going to go into a room together and try not to hit each other. And we'll see what happens from there.
Good. I just wanted one clear.
The prosecutor just asked for clarity with the judge. Man, the first offer that man was given was good. It was really good. Got rid of the misdemeanors down to civil infractions, got rid of everything else. And now the prosecutor's saying, we'll even not hold your feet to the fire on the fines, let the court reduce them as they see fit. And he's still screaming jury trial. Oh man. I hope they have a falling out. I'd love to see this happen on September 2nd. Good morning, everybody. How you doing? How's how's your morning going this hump day? Let it go to trial. I want to see the reaction when he loses. Well, it wouldn't go to trial, Pixel Sensei. I'd say we'd like to watch it in trial, but it wouldn't, because he would get a lawyer, and the lawyer would charge him $900 literally for yelling in his face and saying, "You're an idiot. Take the deal, and you're welcome. Otherwise, we're going to charge you another $2,000 to go to trial." And then the jury will yell at him, "You were an idiot. You should have taken the deal. And here's the full fines and conviction on the misdemeanors as well." How do you like that on your record? Yeah, it's that is so. Want to see Regier? We've got Regier. He's right here. Look at this.
Okay, here he is.
We'll keep an eye on.
Sir, are
Judge
you Lewis Edward Woolard Jr.?
McNally.
Yes, I am.
Defendant does appear in person and pro se.
I wore blue and everyone else is wearing red today. What's with that? I wore red
This, sir,
yesterday.
is your first appearance. You have one charge of overweight limits on wheels and axles allegedly occurring in this county on June 23rd of 26.
We'll go back to McNally as soon as they return. I want to see
And
how that
this
one ends.
is charged as an infraction.
Just pay the fine. I like the maroon and black combo that Mr. Gear is rocking.
That means that there is a fine, a scheduled fine for that. No jail time involved. See if I can tell you what that fine is. Well, it's basically an overweight. You had your truck loaded too heavily, it sounds like. According to the allegations. According to the ticket, your fine is $900, and your court
That's a
costs
big
are
one.
$108.
You're up to $1,008
So if you were
now.
to be convicted either by plea of guilty or no contest, or by the court at trial, the total due would be $1,008. You do have the right to plead not guilty and take this to trial, or you can plead guilty or no contest and you'd be found guilty. The officer's comments, as you've probably seen on your citation, said your split axle weight is 84 maximum allowed for, with the tandem axles being 34,000, and the officer determined your actual weight to be 43,000 on the semi-trailer axles. So that's what you're accused of. And do you wish to plead not guilty and have a trial, sir?
Yes.
All right, we will set this for bench trial.
Everybody's fighting their tickets on the trailer.
Do you have a trial date for that, Destiny?
Your Honor, I do. I still have room left on September 23rd if that works for the state.
No objection to the September 23rd setting, Your Honor, from the state.
You must be back here and ready for trial September 23rd at 1:30, Mr. Lewis. Do you have any questions about that?
No.
Or Mr. Woolard, I'm sorry.
That's all right.
Nope.
Okay. So bench trial again is September 23rd at 1:30, and I generally do those by Zoom. So have any evidence you want here. If you need somebody to testify, you do have the power of subpoena, but you have to do it yourself if you're going to represent yourself. You always can hire an attorney, but I can't appoint one because there's no threat of jail time on this. Because it is filed as an infraction. Any questions or anything I can help you with before I let you go?
No, ma'am.
All right, then you are excused at this time, sir. Thank you.
Thank you.
You're welcome.
I have one more judge, and that is Harley Miller. Miller with an M.
Thank you.
We're watching for Judge Dad to come back. Hello, ma'am.
We're on the record in BU 2026 TR 1278, State of Kansas versus Harley Marie Miller. Jared Regier appearing for the state, defendant Harley Miller appearing in person and pro se. You are Harley Miller?
Yes, Your Honor.
What's that collar
Ms.
frill
Miller,
called?
you are here on one count alleging that you were driving in Butler County while your license was suspended, this occurring June 5th of 2026. Now, this is a B non-person misdemeanor. If convicted, that means your sentence could be up to 6 months in the county jail, although probation is often given. But your fine could be up to $1,000. Time could be given to pay that. You do have, because of the potential for jail time, the right to not only hire an attorney, but the right to apply for court appointed if you cannot afford to hire an attorney. You also could waive your right and represent yourself. So do you wish to talk to an attorney before you proceed, Ms. Miller?
No.
Oh,
do you wish to look into the county attorney's diversion program, possibly getting this dismissed and kept off your record?
Yes.
All right, we will set this over. Are we still doing September 23rd, Destiny, or has that gotten full?
Your Honor, that's a bench trial date. For Wednesday, for diversion, we have October 14th at 9 a.m.
Very well. Okay, Ms. Miller, I'm going to continue this at your request to October 14th at 9 a.m. You must be back here by Zoom at that time, although you can always come to the courthouse as you did today. Don't wait till the week before to start thinking diversion. If you apply and you can't come up with the application fees, call the county attorney and talk to the diversion coordinator, but don't wait. And we need to set a bond. Tell me about yourself. Where do you live? Where do you work?
I live in Wichita and I work for Mays School District.
What kind of work do you do for the Mays School District?
I'm a registered behavior technician in their special education day school.
What does that kind of position require you to do?
I work with behaviorally challenged kids and children with special needs, and I develop like behavior intervention plans and work through some of those challenging behaviors.
Are you married or single?
Single.
And Your Honor, the state does wish to be heard on the issue of bond in this case.
Judge McNally's coming back.
Okay. A single, and do you have any children?
I'm pregnant, but I don't have any children.
Okay. Are you under contract with Mays to get you through at least the year?
Yes, I have a contract through May.
Okay. And do you rent or pay mortgage each month?
I rent.
Okay. How long have you been with Mays School District?
This will be my 4th school year with them.
Okay, go ahead, Mr. Regier.
Your Honor, in this matter, the state is seeking a $1,000 cash or surety bond. The state is troubled by the fact that if the court is prepared to accept a proffer from the certified driving record in this case, it does appear to include a notice of suspension for as a result of, quote, proof of liability insurance was not provided for the vehicle at the time of the accident. Additionally, this is a defendant who appears to have another case currently pending. That would appear to be Harper County District Court Case 26 TR 85. It appears to involve another alleged count of driving while suspended as well as speeding, alleged to have occurred approximately 2 months prior to the current case, April 11th, 2026.
She's doing it all.
Well, Miss Miller, with that kind of information,
may the bridges I burn light my path. She's
you probably fall under the legislature's intent for me to order that you post some kind of bond.
Which means we might be taking you into custody.
Because that is a potential threat to the community, although for some reason they Well, I think I know why. They've started
crying.
cracking down on bonds. They used to want me to give everybody ORs. Now they want me to give everybody sureties. And
You're about to throw a special education teacher in jail.
do you have an extra $100 laying around if your bondsman requires that?
I don't.
Okay. How about 50? Would you be able to come up with 50?
Maybe.
Maybe. You ever been in jail before?
No.
Now it's suddenly serious. Mr. Aguirre doesn't bat
And
an
Mr.
eyelid.
Aguirre says you've had some kind of car crash and you didn't have insurance. Were you convicted of not having insurance?
It was. That was a little over 2 years ago, and that was why my license got suspended. I've been in the process of trying to get it reinstated.
Okay.
Don't say anymore.
What were you going to do about an attorney? Were you going to hire an attorney or apply for court appointed?
Court appointed.
I guess apply for a court appointed.
Okay. Now you can apply for diversion whether you have an attorney or not. You can go to that website that I said earlier, bucoks.gov.
Mr. Aguirre's sending a message in chat saying, lock her up, lock her up.
Who brought you to court today?
My mom.
Okay, that's important.
Is your mom here?
I am here.
Does she have an extra
She's
$50?
sitting in here, Judge.
If I set this bond at 500 cash or surety, would you be able to help her with 50 towards a bondsman?
Yes.
You think you could do that? Because I know you come in here and then that's catching people off guard right and left. They don't come in expecting to pay that.
The reason why I was held up, she had to get a release of liability, and she tracked down the lady that was in the accident with her, and the lady finally signed off on it. There was a lady was Hispanic, and she didn't speak English, and we do not speak Spanish, but she did sign off on the release of liability, and my daughter did submit it to the state, and it says it takes 7 to 10 days to get her license reinstated. She's been fighting this since it started. And we've been given so many different answers. Not the same person, same time. Finally, we did get the release of liability, which was what was holding up the process.
Yeah, I understand that. I've seen that a lot. Well, ma'am, Miss Miller, if you apply for court-appointed attorney, I'll try to see if you qualify. If you do, call back Friday to see if you have an attorney, and you get a hold of that attorney and do what that attorney says. The attorney can help you probably get your license back, or at least give you some pointers.
Might be able to keep you out of jail, too.
I'll see you back here October 14th at 9 a.m. I will set your bond at 500 cash or surety with the requirements that you violate no laws and that you do not drive unless you're legally able to, that your vehicle is insured, the whole bit.
The whole bit.
All right, I'm going to let you go take care of that now, whatever the officers tell you to do about that.
You want us to just set her up a date, Judge, to go out and get that taken care of?
Whatever
next 7 days.
Whatever we're going to do on that, Deputy. Do we have something worked out with the jail on this new law? Are we going to send them out at court time? We can still set them up?
Judge, that's kind of depending on their record. I mean, we can set them up within a week and let them give them a little bit of time to get a bondsman. But if they got a terrible record or they're a danger to society or something like that, then we prefer to take them into custody. We don't have a problem setting her up.
Okay. I don't like using that setting her up, because I just had somebody yesterday say that we were a kangaroo court and we set them up. That was in Greenwood County.
Judge, one other thing I might let you know, I could be wrong on this, but I don't think the bondsmen are accepting $50. I think they're going with about $100 minimum now.
Ooh.
And I could be wrong on that.
I wonder if they had, their lobbyists were behind this change in law, because they're the ones making out well on this.
Yes, I would think probably you're right.
It's good to be a bondsman in Kansas, apparently.
Okay, well, yeah, give her a date to take care of that. If she can't take care of it today, she may want to take care of it while she's here.
Okay, sounds good.
And Your Honor, just to be clear, that is still $500.
Cash or surety required, yes.
Thank you, Your Honor.
You're welcome. All right, we'll be in recess on Miller, and you can give her some time to come in and turn herself in to make an appointment. What you said. All right, Ms. Miller is excused. Who else do we want to take up now? Do you have anybody else down there?
We're going to jump back to Judge Dad. He's back.
You really do. And please don't tell me this under pressure stuff. You're going to have pressure your whole life.
Do we need to back up?
You're going to have pressure to do well in school. You're going to have pressure to make money. You're going to have pressure to be a good parent, to marry a good spouse, whatever the case is. It's just the way it is. I mean, we don't live in la-la land here.
He's in a mood today. We need to back up in here. Hello? We're going to back up. We're going to back up. Let's see. Judge came in. We did this hearing. The girl sat down. And we called this one.
Counsel?
Good morning, Your Honor. Mike Bill representing Ms. Simpson.
All right. If you had a chance, she pled to retail fraud under HIDA. Have you had a chance to review the report? Are there any material additions, corrections, or deletions?
Retail fraud.
I had the opportunity to do the report with my client, Brown. There are no material additions or revisions that you asked for.
That ring light.
This is reasonable stuff. She should be able to comply with, Your Honor. My only concerns are that the court itself, keep in mind fines and costs or circumstances we can discuss.
Say that again.
The only issue, Your Honor, will be her being able to pay fines and costs in view of her circumstance, which we can discuss when the court's ready.
Okay. Ma'am, anything you'd like to say?
At this moment, no, Your Honor.
I'm trying to figure out, when I read this, you graduated from high school. You're going to be a sophomore at Grand Valley State. I'm trying to figure out why in the world you would do this. I mean, you might as well just save all your tuition and book money. Whoever's paying for it, whether it's you with student loans or you because you're trust fund baby or your parents are paying for it, or I have no clue. You might as well just save all that money. Why would you do this?
In the moment, I feel like I was under pressure.
Under pressure. Let me tell you something. You're going to be under pressure your whole life, young lady, to do stupid things. I mean, I'm serious as a heart attack right now. This is disappointing to me. This is really disappointing that somebody that I see has a world of potential here would be going in there and doing something stupid like this. This is stupid. It's just stupid. And I'm telling you, you start racking up criminal convictions, forget it. Don't go to school, save your money. Under pressure, come on. Under pressure.
There's a song about
that. Nobody had a gun they were pointing at you, did they?
No, Your Honor.
Well, come on. Are you going to be a leader or a follower? Are you going to listen to people that are stupid and doing dumb things? Or are you going to be the leader and say, hey, we shouldn't be doing this? This is wrong. We can't do this. We're not thieves. I'm serious. I remember you before. Nice girl. You seem like a really nice girl. You really do. You really do. And please don't tell me this under pressure stuff. You're going to have pressure your whole life. You're going to have pressure to do well in school. You're going to have pressure to make money. You're going to have pressure to be a good parent, to marry a good spouse, whatever the case is. It's just the way it is. I mean, we don't live in la-la land here.
What are the facts of the case?
I didn't want to hear that from you. I want to be honest with you. I didn't want to hear that from you. I mean, you got a 6 months probation. You cannot leave the state without the consent of the court or violate any law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. You're not to enter 22600 Allen Road in Woodhaven or any other miter store. I am taking this under HIDA.
Is it possible that we could work with something to get it off of my record by me wanting to get into things with school?
Yeah, but you're going to use your brains going forward, okay?
Yes, Your Honor.
I don't want to hear this stuff about under pressure. 12 hours community service I'm going to have you do by October the 1st. I'm going to go light on your fines. You have 120 in probation fees, $60 screening fees, 75 victims' rights fee, $50 justice assessment. Fines are 50, costs are 25. So I'm going to go light on you there. That's 200 plus your screening fee is 260 and probation fees are 120 for a total of 380. That's light. 12 hours community service, stay out of Meyer. I'll take it under HIDA. You comply, this case will be dismissed. I'm serious. You seem like such a nice girl. I remember you from before. When I read this morning, I got sick to my stomach.
Yes, Your Honor.
I'm going to give you another review hearing date. You talk to me about when she can pay. Give her a review hearing date, please, Lisa.
February 3rd at 9 o'clock.
February the 3rd.
I'm sorry, you was cutting out. So is it possible you could repeat yourself starting from a hearing date? I didn't hear anything.
No, I'm giving you a review hearing date so you can have the case dismissed if you're compliant. I'll let you appear by Zoom. That'll be February the 3rd at 9 in the morning. Okay? And that will be to have the case dismissed, assuming you're compliant. Tell me how much you can pay per whatever it is, week, bi-weekly, monthly.
As the court knows, she's in school. She headed back on the 28th. She tends to find a job at that time. She's asking the court to be particularly lenient because she thinks she can pay for sugars $30 a month starting August the 31st.
No, I can't do that.
I know, Your Honor. But
you got to have all this paid by February.
I could do 50.
My client doesn't have any financial support. Her mother's passed away. Her father is not contributing to her schooling. She's doing this completely on her own.
$50 a month beginning September 15th. I could make it to September 22nd. But all money due by January the 20th, okay?
Could I start sooner? Is it possible I could start sooner?
You can start anytime
You can
want.
start whenever you want. I'm just trying to give you, I just want to make sure you can pay this. So $50 a month beginning September 22nd. Just stay in accordance with that schedule, but all money due by January, what did I say? The 20th of 27. And the review hearing dates, February 3rd at 9 o'clock. You have to have 12 hours community service done by October 1. If you don't have the money on any given date, no worries. Just call the court. We'll go on Zoom. I'll give you an extension, okay? Don't let yourself down. Do not let yourself down again. Do you understand what I'm saying?
Don't commit a crime to pay the fine.
Where could I start paying my bill and see information regarding my bill and to start paying sooner?
Lisa, have her wait around, and probation will instruct you by video, okay? They'll come on and instruct you by video. Can you call over to probation, please, Lisa?
Get her in a breakout room.
Thank you. All right, so just stay right there. We're going to put you in a breakout room. Don't let yourself down.
Okay, thank you.
Good luck. Study hard. Work hard. That's what it's about. Ventura, Ramon, Mauricio, Flores, Ventura, 267-843-919. Good morning, Ms. Garion. How are you?
Fine, Judge. Thank you. For the record, Marie Garion on behalf of the defendant.
You're going to plead to impeding on behalf of the defendant, correct?
That is correct, Judge. And
You're
I do
authorized to enter in that plea, true?
Correct.
To the charge of impeding traffic. Responsible or not responsible?
Responsible, Judge.
Okay, I'm going to accept the plea, dismiss the improper lane use. This is a commercial vehicle, 225, pay by August the 26th, okay?
Perfect. Thank you, Judge. Have a wonderful day.
You too. Have a great one. Thanks. Bye now. Burroughs. Tarina Burrows. Tarina April Burrows. 267-842-2217.
Where's our Michael Crawford, her name is Burrows.
Where is Ms. Burrows?
She may be out in the hallway. I'm not sure. I saw her before on the phone at the other end, at the clerk's desk. She may have left. I'm not sure. But as you see here, I'm going to withdraw.
Hang on, wait a second. Wait. Wait.
Yell out in the
I can't
hall.
proceed without her being here, though.
I know. Can't do is comply anyway.
257 down there. Sadie. To the desk. No. To the,
257.
257. It's extension number.
That's well.
Well, can you yell out for Tarina Burrows?
I'll do it right now.
Thank you.
Tarina Burrows, get your butt into court.
Well, she doesn't get to just leave.
There's our guy in
I
red.
don't know what's going on.
He's back checking his phone, looking for calendars for
All
court
right,
dates.
let's go to, do we have Scheinfeld? Alexander Michael Stan Scheinfeld, 260-150831.
Michael Crawford, that was approaching.
In shorts and a t-shirt.
Your name, sir?
Al Scheinfeld.
The competency exam
Didn't occur.
didn't occur yet, right?
So we're asking for an adjournment, maybe 60 days.
Did they give you a date? Did you receive a date from them yet, sir? No? Gene,
May his guardian approach you on?
what's that?
May his guardian approach?
Yeah, I believe her, though. What we'll do is, would you call over there to the Forensic Center? Not now, but we're going to adjourn this. I don't know, your name again?
Pamela Scheinfeld.
I don't know why in the world they haven't sent it yet.
It's been, everybody's pointing at everybody saying, this person's gonna get up, this person, I think every attempt possible to get this scheduled. It hasn't happened. But I do want to ask that we make sure that I get the phone call or I get the mail to my house. He lives in an ASC home and that doesn't always get checked the mail. And he doesn't understand if somebody calls him.
Okay, here's what we're going to do. Lisa, give me an adjournment for 30 days. Sadie, call over there and see what you can work out, please. And tell them what she just said. Okay, give me a date out. Would it be the 16th, Lisa?
Yeah, September 16th at 9 o'clock.
At 9 o'clock. And what?
I will be out of the country. I won't be back until the 19th.
Good for you. Where are you going?
My husband and I have a home in Spain. You want to come?
Okay.
That's nice. I just went to Alaska.
Would you like to go
That
to
was
Spain?
beautiful.
No, you got to have one foot out of the U.S.
We've got
I'll
a
tell you
villa
what,
in Spain,
let's
Judge,
make
if
it
you
the
can make this
30th,
go away.
Lisa.
Okay, 8:30.
At 8:30, okay? Fantastic. Good for you. Wow. Nice. Sir, we're going to adjourn this till September 30. Can you get rid of that? Dump that. We're going to adjourn this to September 30. And you have her name and everything, right, Sadie?
Yes.
All right. We're going to take care of this. Thanks for coming, okay?
Thank you.
Good luck, sir. Go down the hall and get your notice. People against Tarina Burrows. Tarina April Burrows, 267-842-2217.
Good morning, Your Honor. Mike Crawford, representing Burrows.
Officer Coffee Run is doing his thing,
Your name, ma'am?
refilling the mug.
What's the problem? Tell me what the problem is. Well, he's your lawyer. You didn't go to law school, did you?
No.
What do you do for a living?
I'm on one post office.
Okay. All right. You've never worked at the post office.
No.
So she probably knows how to do the post office work better than you do.
Much better, I'm sure.
And so what's going on here? Why do I have this? You get a lawyer appointed to you.
Yes. You told me that the last time I was here.
All right. Why don't you throw your gum in that garbage can over there? We're going to have a conversation. What is she doing? She won't listen to you?
Won't listen. And then there's just a break.
They're not a garbage can over there anymore?
Just in general breakdown of communication. I've taken painstaking time, the last hearing and this hearing, to explain the options, nature of how the legal system works. And there seems to be an unwillingness to accept how it works.
Hands out of
I
pockets.
sympathize with it. I sympathize with your perspective. There's a lawyer I tried to explain to
You want to go hire your own lawyer?
I mean, I don't know.
Sometimes she won't even respond to me. She just.
Because he was looking at me.
Hollering at you. He was hollering at you?
Yeah.
Well, define hollering. He was raising his voice?
Yeah, because, yeah.
Am I hollering right now?
No,
Am I hollering right now?
a little bit.
Okay,
so
well-
I can hear you.
Pardon?
A little bit so I can hear you.
I'm gonna let you out.
Thank you.
We're gonna appoint you a new lawyer, but listen, man, I'm not gonna go through this with you.
Here's the.
Okay? You understand what I'm saying? I'll give you a new lawyer.
You're not gonna like
I'll
him
make a
either.
note. Attorney Crawford permitted to withdraw. I don't understand. You know what always makes me laugh? Breakdown in the attorney-client relationship, I'll just write down here. These guys go to school for a while. That's my point. He didn't just wake up this morning and over a box of Cheerios decide that he's going to be a lawyer today. You follow me? He's been doing this for decades.
I understand.
Well, so maybe you need to listen to him. You listen to a physician. I don't know why people don't listen to lawyers. They think they know more than lawyers. I don't understand it. I don't get it, but that's okay. I guess we can all, I pretend I'm a heart surgeon too, I guess.
I guess.
Go down the hall, I'm giving you a new court date. We give her a new lawyer. We're doing September 2nd, Lisa.
September 2nd.
What's wrong with September 2nd?
I think that's the first day of school, right?
I don't know. Are you going to school?
Kid.
You're taking them to school. What time are you taking them to school at?
Some go at 8, some go at 9.
Well, we'll set it for 10. We'll set it for 10:30. You can be here by 10:30, right?
Yeah.
Is that a good time for us, Lisa?
Yes, that's fine.
Pre-trial will be September 10th to September 2 at 10:30. Okay?
So I'm going to try.
No, we're giving you a new lawyer, and your lawyer's going to pre-try it. And I hope you listen to this one better than you listen to him. Okay? You know, doctors don't always give us good news either, right? Right?
Yeah.
I mean, I don't want to go have a doctor tell me I got something life-threatening, right? But it is what it is. Good luck, Kennard. Aaron Jordan Kennard, 25G306-491.
A lot of attitude.
Could I also have over here Aaron Stover, we're going to do next. Your name, ma'am? How are you today?
My name is Bernard.
Counsel, what have we got here? We got a charge of failure to attend the Retail Fraud and Economic Crime Program, failure to pay fines and costs as ordered, and I actually took a plea on June 18th to these charges. I took this under section 771.1. And what did I write down? I said set sentencing for July 22nd. That was on June the 18th. And then I said retail fraud program to be completed. Defendant currently was in the hospital August 5th, so we adjourned it. Can I have Jessica in here, please? Somebody call Jessica. What do you want to tell me? You got some good news for me, Mr. Crawford, or am I going to...
My client is here, glad to report she's paid all fines and costs. She's completed the class, and she is hoping to be released in probation, and she's done everything the court has asked the state. He's so grateful the court gave her some additional time.
Why'd they do that? And get too nice, right?
The court's kind and benevolent.
I love that word. All right, let me just check some. Are you going to grow up, young lady?
Yes.
Sure.
There's so
Jessica, tell me your name, please.
Just put on there.
She did it?
Everything's completed, Your Honor.
What are you gonna do now?
Her case technically is eligible for early release at this point. We had moved her prosecutor review and kept pushing it back until today. Today would be exactly a year from when she was sentenced, so she'd still be eligible to take the 771 status if the prosecutor is okay with it.
This is Gibraltar, right?
This is, I don't know if it's the correct date. We did have to push that she was in the ER the last time for her visit, for her appointment or her hearing that was scheduled. So we did move it, so there may have been a miscommunication on being on the right date for Gibraltar's.
Would you just write down defendant? She's compliant. With
On there at the very bottom, she's running out of room on the ROA there, but I wrote that she's compliant, all terms and conditions have been met. At the bottom of the ROA.
All right, let me just check something here. August 28th. Are they by chance Gibraltar here next week?
Here next Thursday.
Good.
The 27th.
Okay, so you're gonna have to come back, okay?
On Zoom for that.
Yeah, you can do that. Here's what I'm gonna do on this. I'm not gonna do anything. I'm just gonna note you had 2 technical violations. I'll keep you on probation. We'll set it for prosecutor review. 8/27 at 8:30. How's that? And you can appear by Zoom.
Okay.
You know how to use Zoom? You sure you know how to use Zoom? All right, use Zoom. And then they can dismiss and everybody will be happy, okay? Have a great day. Good luck.
Thank you, Ron.
Judge, can I approach on another matter real quick?
Yes. It's always trouble when you're...
So I got a phone call from Melissa De Palma, who's in custody back there. She's trying to get out of her jail sentence. She wants to talk to you again. I said, once you go back there, there's not really a redo again. But I said I would ask, but I just wanted a heads up that she's giving them a hard time wanting to come back in here.
Another bite of the apple.
She's giving John a hard time, so.
Well, maybe I'll have her come back in. Let me take care of it.
Okay, no problem.
Have John bring her back in, but I need the file again.
Okay.
William Stover, 267-843-969.
He's having a day and a half today, man.
Good morning, Your Honor. Attorney Christopher Smith, P number 83547. I'm standing in for Attorney Gary Giannetti on behalf of Mr. Stover, who's not appearing via Zoom, but this is a civil infraction, and I think we have.
So they're going to plead. You're authorized to plead on his behalf to impeding, right?
Well, I wish it was impeding.
Oh no, it's 11 to 15 over.
Yeah. Yes, I'm authorized to do that.
What did he do? What did he do?
He was speeding.
Well, allegedly, he went past he failed to yield to an emergency vehicle. I think the police was on the side of the road, and I think he
realizes. Let me slow you down. He realizes this is 3 points, right?
Yeah, and what I was trying to ask the prosecutor is how many points was the one that he was originally charged with? And then I think we came up with the number is between 2 to 4 points based on how the ticket is written. So I was thinking that it would be 4 points the way he was, the way it was written up. But if it's less,
look at least failure to respond, failure to yield to an emergency responder. How many points is that again? Do you know?
How many points do you get before your license?
I would have to look that up real quick. Let me see.
Problem is that looks a lot worse than 11 to 15 over, if you don't mind me saying.
Right.
I mean, I don't care what you guys agree to or do. That's fine with me. If you want to plead this charge, I could care less.
It's 4 points, Judge.
It's 4 points. So he's saving you a point.
Yes. He was a very, very tough negotiator back there. He wouldn't go for a failure to use due care and caution, 2 points. So, but we do want to take advantage of the offer because it does save a point.
All right, to that, and you're authorized to enter that plea on his behalf.
What's the fine on that one?
Yes, Your Honor.
To that charge, failure, 11 to 15 over, responsible or not responsible?
Responsible.
Plea is accepted. The original charge dismissed. I'll save you some money, okay? It's $300. Have them paid by August the 26th.
Thank you so much, Your Honor.
Save the
Have a
money for
good
your
day.
insurance.
Thank
You too. Take care.
Thanks.
12 points and you're done?
Mr. Palmer,
Go to break the poll.
I need her file. Do I have her file?
I don't know, Judge.
Okay, don't
It's the
get frustrated.
troublemaker?
What's the case number, Sadie?
I think Justice said it's still on the thing here.
This is the girl
Oh,
causing
come
trouble
on.
back there?
Okay, I got it. 23W832-679A
B.
and B. Your name? I'm not gonna change my mind. You can't keep doing this.
And I promise you, if you just give me this chance,
No.
I will not upset you.
No, you've had 5 or 6 of these. You just got another one in front of Judge Hessen. No. I'm not going to change my mind, and I don't want you giving these guys a hard time to. Ma'am, listen to me. You have led a life of crime. I'm not going to change my mind. I don't get up and just decide over willy-nilly over what I'm going to do here. I have done something. I didn't give you 90 days. You deserve 90.
You know, at least get a second good fair order.
No, I'm sorry. You cannot keep doing what you're doing. No. You just did this in front of Judge Hessen. You just had another case in front of Judge Hessen. You've had 2 in the last year. Don't tell me you've seen the errors in your ways. I've never had one person come in here and say, I'm going to do this again.
No,
I don't care what you think, Judge. I've never had one person do that. Listen to me. I don't want you giving these guys a hard time. I've made my decision. I'm not going to change my mind. If you say something, I'll let you talk. But if I let you talk, I might make it worse. Do you understand what I'm telling you? This could have been worse. It should have been worse. Do you still want to talk? Pardon? Go to the back. I'm sorry. Good luck. Zidlowski. Kimberly Jean Zidlowski, 26W842778. Is that yours? Zidlowski?
We missed her. She was at the beginning of the block.
Nice to see you, Mr. Ferguson.
I was saying, I saw you that day, but didn't get for one. The next day, I got a case of it.
Oh, jeez. Your parents?
But Gene Ferguson, Ben Kimberly Zidlowski, stands to my left.
Ma'am, your name?
Kimberly Zidlowski.
All right. So for purposes of arraignment, does she stand?
Standing and wait for Paul.
Okay. There must be a misprint on this ticket. She's Kimberly Zidlowski. And it says, did harass neighbor Kimberly Zidlowski on multiple occasions. So I don't know what they're talking about. So it must be Andrea Bealby, I guess. That's the other thing that's listed here. So I'm going to give you $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law, ma'am. You must appear in court as directed. I am going to order you to go over and get fingerprinted and photographed, okay? You have to go over and get fingerprinted and photographed at the Woodhaven Police Department by 1 p.m. today, by 1 p.m. on August the 19th. You have to go over there and get fingerprinted and photographed. No contact with the victim, Andrea Bealby. No firearms. I don't want you to possess firearms or dangerous weapons. You don't have any weapons, do you, man?
No.
So no contact with the victim, no contact with prosecution witnesses except through your lawyer, and you have to go over to Woodhaven Police Department to get fingerprinted and photoed by 1 p.m. today, okay? And let me just make a note of this here. Let's see here. Peace.
We know for the court that she lives next door to the victim.
I know.
So,
ma'am, here's what I'm going to tell you. If you see her outside, I'm going to expect you to be nowhere near her. Do you understand that? I don't want you to, you're not going to have any conversation with her. You're not going to talk to her. You're not going to write her. You're not going to email her. You're not going to text her. You're not going to say anything. And I would, and just to make sure, if I saw her go outside, I would go inside if I was you. Then there's not going to be any allegations that you violated a no contact. You understand what I'm saying? Ma'am?
Yes.
Do you understand? I mean, wanted to talk to your lawyer. If there's something you have to say, ask me.
I understand.
Okay, good enough. So I'll enter a not guilty plea. We're going to give you, is this September 2nd, Lisa?
Yes, 9:30.
Are you good with that, Mr. Ferguson?
Yeah, I have something else downtown.
That's okay. You want me to make it the 16th? Is that better for you?
16.
We'll make it the 16th, Lisa. What time?
8:45.
At 8:45.
We'll get it.
Okay?
And Madeline, could it be by Zoom if she's in my office?
Absolutely. Absolutely. As long as she's with you. Have a good day. Thank you.
do
Good
the
luck,
red.
ma'am. You're going to go down the hall and get your notice, okay?
Let's do the red shirt guy.
Cameron Ross.
Yeah.
Let's see what I have here. I've got 26W843. What? Pete.
See if they
See
worked out
back
their
here.
differences.
Rover.
Looks like they still don't like each other. We're going to call the prosecutor in.
26W843-633.
There's one.
26W843-649.
There's two. There's that look from the judge.
648A and B.
3 and 4.
And then I've also got 26W843-824.
5.
And 26W843-747.
That's 6.
All right. Your name? Could you call in Mr.
Prosecutor?
Urick, please. Your name, sir?
Cameron Ross.
All right. So first of all, let me just indicate that on these 2 civil infractions that are assigned to me to prohibited parking, he's going to dismiss both of those.
Oh, he took a deal.
Is that your understanding so far? All right.
Yes, he says. Prohibited parking is dismissed.
It's okay.
And then on the other 2, 3, or 4, see, there's 4 others that are assigned to Judge Hessen. You're going to plead to 2 counts of public nuisance. They're going to dismiss the misdemeanors. I want to make sure I understand this. Your name?
William Urick on behalf of the city of Winhaven.
So he's going to plead to 2 counts of public nuisance violation under section 110-106, right?
Correct, Your Honor.
And that's going to be on the 649 and 633 cases, right?
2 misdemeanors, yes, Your Honor.
All right. So he's going to plead to that, public nuisance violation.
Commercial parking. Commercial
Civil
vehicle parking.
infraction, which is punishable by up to 500 in fines, correct?
Correct, Your Honor. The people have indicated they're not seeking the maximum.
I understand.
Fine. Thank you.
And then I'm going to go ahead and dismiss the 2 civil infractions that are assigned to Judge Huston, prohibited parking and failure to change address. And I'm going to dismiss the prohibited parking and 2 prohibited parkings that are assigned to me, right?
Correct.
Sounds like you took
Is
the
that
deal.
what you want to do, Mr. Ross?
Yes, Your Honor.
To the charge of public nuisance violation under Code Section 110-106 on file ending in 649, how do you plead, responsible or not responsible?
Responsible.
Just saved a bundle and an
And
attorney
on
money.
public nuisance violation 26W843-633, how do you plead, responsible or not responsible?
Responsible.
Of course, you're going to pay 500.
You're sure you want to do this as opposed to go to trial?
Yes, Your Honor. I don't want to go to trial. I didn't think the fees at the time were right for some of the tickets. I would think.
I just want to make sure this is what you want to do.
Um,
Nobody forced you to do this.
what is the fee amount we requested, Your Honor?
I haven't said it yet. I just want to make sure this is what you want to do.
Can I make a decision after that?
No, I don't tell anybody what I'm going to do before I do it. Now he wants a cop's plea on civil infractions. Is this what you want to do?
Yes, Your Honor.
All right. Anybody force you to do this?
No, Your Honor.
And I'm going to accept the pleas. I'm going to dismiss. The no trailer plate charge, the parking misdemeanor of the truck or trailer on the street. I'm going to dismiss the two prohibited parkings that are assigned to me, 824 and 747, and I'm going to dismiss the two civil infractions that are assigned to Judge Hessen on 26W43648A and B. All right. Anything else that you want to say?
People have nothing for.
Anything else?
No, Your Honor.
If you want to argue why you shouldn't have to pay a lot, feel free.
I had just purchased the boat. This might be false, but I was under the impression that I had 15 days to get the.
What lawyer told you that on the street? That's what happens. These guys all think they know so much. Right?
Didn't know how else to get the boat and trailer home and then get the plate. I couldn't.
Same way you do it with a car, right?
It was a private sale. It wasn't.
I know, but you should go to the Secretary of State and get the insurance and everything and get your plate taken care of. Just like I would do if I bought a car from you.
Like before I picked it up, you're saying?
You can do it however you want. I mean, yeah, before you pick it up. That's what I would do. I would have them go right with you to the Secretary of State if you're buying a boat from somebody.
The boat was in Florida. I went personally to pick it up in Florida.
Okay, well, I don't know what to tell you. Look, I'm going to charge $165 per ticket. Okay? Yeah. But listen, don't be so belligerent with these guys. It sounds like they're getting a lot of flack from people. Now you see
neighbor that just hates me. You call the police every day. I mean, it's.
You know what I would say? You'll give them no reason to call the police if you're compliant with the law, right? I mean, if he keeps bugging the police, they're not going to like him very well if he keeps bugging them and you're not doing anything wrong. You know, that's the other thing. Guys, the police are picking on them. I get that all the time. Well, don't give them a reason to pick on you. You know, if you're not doing anything wrong, they can't pick on you. What are they going to do? They got nothing to write. Just be nice, will you? Comply with laws, will you please? Thank you. Faith Robbins. 26W843-927.
Michael A. Carmen, P73824. I'm happy to defend Your Honor.
Good morning, ma'am. Your name again?
Me, Robinson.
Is she stand mute, wait for my reading?
Yes, sir.
And I'll let her not guilty plea. Now, as I understand, she's going to plead guilty under Ayden to child endangerment. True?
Yes, Your Honor.
Ma'am, if you do that, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, I'm going to take it under Ayden. I'm going to set terms and conditions of probation when you come back. And if you're compliant, that case will be dismissed. Do you understand that?
Yes.
You understand everything? All right. You understand if you plead guilty, you're giving up all the rights on that advice of rights. And you understand we won't have a trial then?
Yes.
Okay. To the charge, child endangerment or neglect, how do you plead?
Like,
Do you live at 23580 Williamsburg Circle, Apartment G in the city of Woodhaven?
yeah.
Were you living there on July 22 of 26?
Yes.
Did you have a 1-year-old daughter?
Yes.
Did you leave the daughter home?
Yes.
With nobody attending to her needs?
Yes.
And did you do that for more than 2 hours? How long did you do that?
Well,
Where'd you go?
I was looking at her car seat from her father, and then I went to the grocery store to pick up my medicine because she was vomiting.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Well, you just can't do that. I'm going to give you a pre-sentence report. We're going to sentence you $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Are we doing this on the 2nd, Lisa?
Yes, 8:30.
At 8:30 in the morning. Come on. Can't do that. How old are you? How old are you?
19.
Is the father in the child's life?
Yes.
Is he paying you child support? Why not?
Where he doesn't, he contributes still, like, he's involved in her life.
Yeah, but doesn't he give you financial support? I mean, a father should be involved in their kid's life, right?
Yeah.
They should be nurturing and loving and try to teach them. They still have an obligation to provide financial support.
Yeah.
Why isn't he doing it?
He does.
Okay. So he works.
Yes.
Okay, good. All right, we'll see you back there on September 2nd.
Oh.
Okay, you're a better mother than this. I know you are. Okay? All right, good luck. We'll see you back here. Go get your notice and then go over to probation where you'll be interviewed. Scott?
It's dangerous. Old-time gamer.
Robert Charles Scott Jr.,
Congratulations on 1 month.
267-843-975, A and B.
Good morning, Your Honor. Michael Paul, and Mr. Scott, who's approaching. Come to the podium, state your name. Dr. Johnson.
All right, does he stand mutely for my reading?
You do.
I'm entering a not guilty plea for purposes of arraignment. Now, as I understand it, he's going to plead to impeding traffic and allowing an unlicensed driver to drive, correct?
Correct.
Is that what you want to do, sir?
Yes, sir.
If you plead to allow an unlicensed driver to drive, that's punishable by up to 500 fines, 90 days jail. Costs are all the...
I'm going to mute him for just a second. Do you want us to go back and watch that, the girl, the first time she appeared, the one that was giving the people a hassle and back? I sort of want to see what went down the first time with that. So I'm going to rewind just a little bit. Let's zoop backwards here. Let's see if that was far enough or too far. I think it needs to go a bit further. Lady in red. That's not it. We saw her just before this. Her lawyer's there. It's the first block after he came back from the break. Here she is. Hang on. Let's see what happened in this one. Then we'll skip to current time. This is right as the judge came back from the break after he just sent the trucking guy. Oops.
Attorney?
I'm at 24W835-466A and B. I also have 23W 832679A and B.
So 4 charges.
Michael Paul, all station correct.
She pled guilty to retail fraud emanating from a December 29-23 incident. She also pled guilty to giving false information to an officer. She also has pending in front of Judge Hessen.
More retail fraud.
Refused to obey a police officer and retail fraud.
Yeah.
She's not been sentenced in there yet, right? So I don't need to worry about those. Did you review this report with your client? Are there any material additions, corrections, or deletions?
Yeah. My client, there are other material additions, deletions, or revision that we asked for, Your Honor. She understands what the recommendation entails. She believes she can comply. We asked the court to adopt the recommendation as presented.
I have to be honest with you. Why am I putting her on probation again? Why would anybody expect her to go on probation in front of me?
I can't speak much really fast.
09, retail fraud. Larceny by conversion, 13. Retail fraud, 14. Retail fraud, 16. Retail fraud operating while impaired, 26. Another retail fraud and refusal. I mean, I don't know why they would recommend this. I'm sorry, I just don't.
Well, Your Honor, my client needs some help. She admits that she needs some help. She's got a problem. She started the process of trying to get some help now. So her thought, and my thought, I agree, is that the court can help by putting her on probation, giving her some guardrails, making sure she gets in an intensive outpatient substance abuse. She wants to get this under control. She knows her past is terrible. She knows the prospects aren't good. She continues down this road. She wants some assistance. So I think that's why the court might consider probation.
Anything you'd like to say, Ian?
I mean, I've had to go to the home for quite some time, I am, I'm starting to get it under control.
You what?
I'm ready to get it under control.
On the false information, 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 or 90 days. On the retail fraud, 100 fines, 250 costs, 75 victims' rights fee, $50 justice assessment, 475 and 45 days. I'm going to add 45 more if you fail to pay your fines and costs on that. I will let you pay these at the rate of $25 per week, and I will start that beginning on October the 30th. If you don't have the money, you come talk to me. And actually, on the false information, I'm simply going to make that easier. 3 1/4 or 45 days. So that'll be taken care of. You have a bond that's the name of a third-party poster, I believe, Lisa, on the, yeah, it's a third-party poster.
Yes, third party.
So that's what I'm going to do. We're going to close out the false info, or at least, and the other one, she'll just, third-party poster can get them. I'm sorry, Mr. Palmer. Let it go too far. I wish you well. Have a seat. You have 21 days to appeal, 14 days to apply to a court-appointed lawyer for purposes of appeal. Good luck. These are going to Judge Hudson. You can tell her I gave her 45 days. Thank you. Courtney Regina Simpson, 26W843-720.
Yes, Your Honor.
Okay, there we go.
Name?
Courtney Regina Simpson.
Counsel?
Well, Your Honor, like to represent Ms. Simpson.
Now we're going to
All
fast
right.
forward again. All right, back to current. Judge.
We're doing those tomorrow.
Okay.
Oh, he's done.
I know.
Let's see what's his final word.
Fines costs, I'll go kind of light on those later than I usually do. 150, your total's 5 1/4. When can you pay that?
Can't pay that today, Your Honor. He's asking for a payment like he must pay $100 a month starting on September 4th.
Okay. Lisa, 100 a month beginning September 4th. We'll have him pay on the civil infraction first. So you're going to pay that on September the 4th. You're going to come in and pay 50 more on October the 4th, and then you're going to pay 50 more on October the 4th on your other charge. Okay? So $100 per month. If you don't have the money, you come in here and ask for an extension, or you can zoom in and I'll be glad to give you one. Okay?
Yes, sir.
I wish you well. Good luck. Thank you.
Good.
All right. How much more?
Mr. Crawford, do you have any more? Think so.
We're all set?
Think so.
Thank you.
He's already got a headache from this court this morning.
Gotta figure out that competency.
See all these no-shows?
That.
We're doing
I
those.
would have been sent.
I know. We're doing those tomorrow.
Okay.
So.
And he's gone. All right. Judge Dad had a successful morning. Judge Webster still at it. Let's see. The child was 1. Yeah. She left a 1-year-old child for more than 2 hours home alone. Bad setup. All right, let's take a look and see where we can go. Ooh, we just got one that went live. San Jacinto County. Let's do a quick check there. It's this one right here. Well, he looks like a ghost. It's the lighting. The ghost of judges past has come back to preside over a case here. Let's see what's going to happen here. Going to move back to my regular position and see if that'll work here. And your
name? Maya Bryant.
Ms. Bryant, I'm Harris Blanchett. I'm the Justice of the Peace. You're in. And your name?
Maya Bryant.
Ms. Bryant. Okay, Ms. Bryant, you are charged with the offense of aggravated assault with a deadly weapon, a felony in the second degree. Do you understand the charge?
I understand the charges.
You have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys that represent the state. You have the right to remain silent. You're not required to make a statement. Any statement you make can be used in court against you, and you can stop any interview or questioning at any time. And you have the right to an examining trial. Do you understand those rights?
Yes, sir.
Do you need a court-appointed attorney, or are you going to get your own?
A court-appointed.
All right.
I have a document to read here. Hang on.
Are you a citizen of the United States?
Yes.
Are you currently out on charges anywhere else in the state of Texas?
No.
Yes?
No.
No? Okay.
Yes, no, maybe so.
I'm going to set your bond at $10,000 for the felony in the second degree. All right. I'm going to send a form over there today or this morning showing that I've read your rights. I'm going to ask you to sign that showing that you acknowledge your rights. And then I'm going to send, let me just finish one more thing. Then I'm going to send a form over there for you to fill out.
He means
for
form.
Your financial information to see if you get the court-appointed attorney. Once you fill out that form, I send it to the judge, and the judge in the court that will try your case will determine then if you're eligible for the court-appointed attorney. Do you understand that?
Yes.
All right. What's your question?
The house I was at last night, the officers didn't let me get a word out. The men in the house, I'm literally outnumbered by them. I was in fear of my freaking life.
You'll need to save that. You'll need to save that information for when you go to court. Be sure and tell your court-appointed attorney that information.
When am I supposed to go to court?
Well, yes, ma'am. Yeah, be between you and your attorney if you want to go to court or not. But I'm going to send that financial form. You fill that out, and I'll turn it in to the district court judge, and he'll determine if you're eligible for the court-appointed attorney. All right?
Okay, but I do have a bond.
Yes, ma'am. Your bond set at $10,000.
$10K.
I don't get 10% or nothing.
Ma'am, I couldn't understand you.
I don't have to. I can't just do the 10% of that or nothing.
You what?
I can't do like the 10% of that or nothing, like half of that.
Well, your court-appointed attorney can request a reduction in your bond. Yes, ma'am. And then we'll have a hearing on that.
Because I never touched nobody or anything. They have no evidence I touched nobody or nothing. I was scared for my life. I'm outnumbered in a house full of males. My boyfriend is in his 40s. His kids are my age. They're jealous of me. They go out their way to keep bothering me. They can see where I text my boyfriend all day. His sons was messing with me, touching me, bothering me, putting their hands on me, to where I felt like I had to go in the kitchen and put something in my hoodie in case they come touching me again. And I'm scared, sir. My 1-year-old son is still in that house. I don't know what.
That'll come out in your trial. That's not to be considered by me at this time. I'm only here acting as a magistrate to read you your rights and set your bond. You'll need to talk to your court-appointed attorney and give him those details.
Yes, ma'am.
Any other questions I can help you with?
No, thank you. I just know I'm not guilty. I never aggravated, assaulted nobody with nothing. So I'm just praying I get to go home to my son. I pray my son get away from this house. I don't know what's going on with my son at this house. I really wish I could send somebody to go get my child so I get up out of here so that I don't feel safe for him to be there.
Yes, ma'am. You just need to tell your court-appointed attorney all those details.
Okay.
Thank you. If you'll knock on that door, they'll come get you out.
All right, sir.
That's it.
Yes, sir.
All right. You have anybody else you need me to see?
No, sir, that's it.
All right, thank you.
Thank you, sir. Have a good one.
That little beard goatee has seen a few things. It's been around the world in 80 days or something. I don't know. Wow. Judge Stevens has a jury trial. We've got a couple things going on. Let's see, we've got Judge Clark. He's doing felony hearings down in Florida. Lots of drug stuff in that one. Judge Webster's still hearing things. Like hearings. Judge Stevens, you said? What's Judge Stevens up to? He's on a break. What was
The witness was passed for cross-examination, and the defense may question the witness.
During your redirect,
let's go back and see how this one starts. Wait for the judge to show up, which is about right here. There we go. See how this started. See if you want to stick around for a bit.
Looks like John West and Brent. Where are they?
they're outside.
They can come in.
I think we might have a document out of Utah to read.
Who is?
Just a second.
Harold's making an announcement.
That way I can do it. You have it?
No.
That is, that's one of the ones you saw for a long time.
Did any of y'all see any lawyers out there? That's what we need is some lawyer. We need a couple of lawyers.
Here, Brent Church here.
Where are they?
He's right there.
Just grab a lawyer. Any lawyer will do.
Does he know we're going to have to come inside?
No, he thought we'd go out there.
He's just staying in the doorway?
He thought we were gonna meet him.
You're invited, John. You're invited in. Just,
That's right.
oh, now I thought you were stuck in the doorway.
Silent. Take care of stuff. Sorry.
Where's Turk? Mr. Turk?
He's here.
Somewhere?
He might be in the back somewhere.
He's outside too? Yeah, he's invited.
You wanna,
Who's Thaddeus Jolly? Are you here? Thaddeus Jolly? See that?
Mr. Thaddeus.
What about Nolan White? Nolan White? No. Maybe he's talking to those two. Michael Daigle? Come on up.
I think we've got some reading to do instead of watching this, so give me just a second. Download.
oh, right. Oh, right. Sure. Thanks.
It's a lot of reading. It's in the Tyler James Robinson case out of Utah. The state just filed their response. It's not a ton of reading. It's not like 41 pages.
Jimmy's off. Did you get Jimmy's off on?
Remember, this was the closing arguments to the preliminary hearing for Tyler Robinson.
You're Michael Daigle?
Yes, sir.
And you're here with Mr. West, John West, your attorney. You, sir, are charged here in 26 CR 976 with the third-degree felony of deadly conduct by discharging a firearm. So this states that you knowingly discharged a firearm at or in the direction of habitations, homes, and you were reckless about whether the homes were occupied. Namely, by discharging the firearms in a residential neighborhood without regard to the direction you were shooting and the impact of the bullets on the residents. Did we have another defendant in here on that same thing? The guy that was in the shooting the neighborhood up and then a week later was at the park, shooting at the park. Was this the same?
Was that incident? You? I'm not sure, Judge. This is Jimmy Ham's case. He does have some from the.
Who else was with you on it? Were others with you?
That's what this is about.
Were others with you?
Oh, yeah.
Okay.
There's 3 of them all good.
Yeah, that must one of those other guys must have been in here. All right. This is treated seriously. It's a third-degree felony, which carries with it up to 10 years in prison. No less than 2. If you're convicted, you get no less than 2 years, up to 10 years in prison. Now, if you're eligible for probation, a form of probation is an option, but that's for him to talk to you about. But this legislature enacted this with serious punishment, and nobody wants to go to prison for 3 years. And in this case, I think if you went to prison, you would have to serve at least 50% of your time because a firearm was used. And so if you do 10 years, you won't get out until 5 years at least were served. So it's all serious. Don't do this again.
Yes, sir.
All right.
You're going to just slap him on the wrist.
You know, this is the initial, so I need to go.
Certainly is.
But, there's an offer on the table. I think it should be worked out, but if we get about 4 weeks, I can go over everything with them and then be prepared.
You're appointed on this?
Yes.
I'll give you 3.
That's fine too. I can do it too if you need to. I mean,
2's okay too. Let's move this if it has to be moved so we know what direction it's going to be in.
All right.
And besides, if y'all work a deal for deferred probation, the quicker he gets on it, the quicker it ends.
And that's what's on the table, Your Honor.
I don't know. Some defendants never figure that out. And if it's deferred, which you're not found guilty, it's a second chance. But don't make another mistake like that, because there's a lot to lose on that. But you get a second chance, and
Your Honor.
You want to take advantage of that and do the best you can do. All right, get a reset. Nolan White,
and then dress appropriately for court. All right, we're going to do some reading. Are you ready? Are you ready? We want to hear the response that the state has. Yeah, a mistake. They call it a mistake, firing a gun into houses, not knowing if they're occupied or not. Oopsies. My bad. My mistake. Yeah, not cool at all. All right, give me 1 second to get this pulled up. Downloads, document 12. Open with preview. We're going to throw this over on screen number 3. All right. It's reading time, but I have to put this in the title first. Court watch, edit. Utah prosecutors respond to Tyler Robinson's defense. There's more to it than that, but that's where we're going to what we're going to call it. A dramatic, we have a dramatic reading. You're asking for dramatic reading, Troy? I was just going to provide the reading and leave it at that, but I guess dramatic reading is what we're going to get. So this is the last paperwork we're waiting for before we have the judge issuing a ruling in this on the preliminary hearing to let us know if there is reasonable, if they've met the threshold, the prosecution has met the threshold with evidence to continue to trial against Tyler Robinson in the shooting death of Charlie Kirk. Valerie, we'll see it for Tupac. We'll be there for Tupac. It's going to start at 4:00 Eastern time. But meanwhile, we've got to figure out what the state thinks is enough evidence to go ahead, and this is in reply to the memorandum in support of preliminary hearing bindover. All right. Defendant does not challenge the substance of the evidence demonstrating that he was the person who crawled to the sniper's perch on the Losi building rooftop, fired the fatal shot that killed Mr. Charlie Kirk, hid the rifle in a wooded area, got rid of some of the clothing he was wearing, and told his roommate to delete their text about the shooting. Rather, he merely asserts that the repeatedly rejected claim that the overwhelming evidence establishing some of these facts could not be introduced as reliable hearsay at this preliminary hearing. Defendant therefore raises no valid challenge to the evidence supporting count 1, as at least murder. Count 2, felony discharge of a firearm causing serious bodily injury. Counts 3 and 4, obstruction of justice, or count 5, tampering with a witness. Defendant challenge to the aggravating circumstance for count 1, that he knowingly created a great risk of death to another, is based on his misrepresentation of both the evidentiary standard at a preliminary hearing and the test for establishing the aggravating circumstance. As for the evidentiary standard, defendant erroneously asserts that a magistrate engages in speculation when he chooses between a reasonable inference that supports guilt and a competing innocent inference. The Utah Supreme Court has rejected that logic, a fact that the Utah Court of Appeals has repeatedly recognized. Defendant's counsel ignore this controlling case law and have therefore violated their ethical duty of candor to the court. Oh, shots fired with that one. The state just accused Ms. Nestor and her team of violating their ethical duty of candor to the court. Contrary to the defendant's argument, that's something that can get your hand slapped quite severely by the bar. Let's see. Contrary to the defense argument, these cases establish that when a fact finder chooses between reasonable inferences at trial, it is properly fulfilling its fact-finding role, not speculating. Thus, even at a trial, a fact finder is free to choose between reasonable inferences. This is a preliminary hearing where this court does not sit as a fact finder. Instead, this court is duty-bound to draw all reasonable inferences in the state's favor. It is therefore even more apparent that in this proceeding there is nothing speculative about viewing all reasonable inferences in the state's favor. As for the great risk of death aggravating factor, or GRD, defendant erroneously, I'm not sure if they're going to use the abbreviation later on, defendant erroneously maintains that the test for establishing this factor depends on the presence of some minimum number of factors or circumstances. In fact, Utah Supreme Court has expressly disavowed such an analysis. Instead, the governing test is the one the statute provides, whether a defendant knowingly created a great risk of death to another. The evidence here easily establishes at least probable cause to believe that the defendant did so when he intentionally fired his grandfather's high-powered rifle towards a crowd of thousands, several of whom were in line of fire between him and Mr. Kirk, while others were in proximity to Mr. Kirk. Indeed, the evidence is more than sufficient to support a finding beyond a reasonable doubt. So that's enough for a conviction. Defendant's challenges to count 6 of witness tampering for directing Mr. Twiggs not to talk to police, and 7, violent offense in a child's presence, likewise improperly draw inferences in defendant's favor, not the state's, while also ignoring relevant evidence. Defendant's challenge to the victim targeting enhancement on count 7 similarly ignores the evidence. Finally, The defendant also misrepresents the holding in Apprendi versus New Jersey in arguing that the sentencing enhancements for committing a violent offense in a child's presence and targeting his victim must be proven now. Welcome, Laura. Neither enhancement implicates Apprendi because neither increases the maximum statutory mandated punishment. Defendant misrepresents the governing evidentiary standard because he relies on erroneous distinction between inferences and speculation that the Utah Supreme Court has rejected. Defendant misrepresents the evidentiary standard that governs this preliminary hearing because he relies on an erroneous distinction between the inferences of speculation from State v. Cristobal that the Supreme Court soundly rejected over a decade ago in State v. Ashcraft. The Supreme Court explained in Ashcraft that when a jury chooses between reasonable inferences to reach its verdict, it does not engage in speculation. This is even more true at a preliminary hearing, where the magistrate must draw all reasonable inferences in the state's favor. Because he ignores the case law that rejects the logic on which his argument depends, defendant erroneously labels as speculation many of the state's arguments about the evidence and the reasonable inferences this court must draw from that evidence. Defendant's memorandum at 11, 16, 19 through 22, 29 through 30, and 32 through 33. For example, although the evidence demonstrates, 1, that a clear line of sight existed between the defendant's sniper perch and Mr. Kirk's seat, and 2, that others were near Mr. Kirk when the defendant fired the fatal shot, defendant asserts that this court would be engaging in speculation to infer from this evidence that the defendant actually observed security personnel or others standing near or directly between him and Mr. Kirk. Similarly, although the evidence shows that the defendant loaded his rifle with 4 cartridges that had previously done target practice, where he seldom hit the bullseye and sometimes missed the target completely, defendant asserts that it would be speculative to infer that he knew he would miss his target. He could miss his target. Defendant relies on State v. Cristobal to justify his argument. Quoting Cristobal, defendant asserts that when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. But the Utah Supreme Court rejected Cristobal's logic in Ashcraft, a fact that the Utah Court of Appeals has expressly and repeatedly recognized. These cases make clear that choosing between competing reasonable inferences is not speculation, but rather exactly what a jury must do. The defendant in Ashcraft argued that the existence of innocent inferences for his presence in a known drug area late at night with a large amount of cash rendered the evidence insufficient to support a jury verdict that he constructively possessed drugs. That's what happened in Ashcraft. So he said, that the existence of innocent inferences for his presence in a known drug area late at night with a large amount of cash says you can't say that I had drugs. Consistent with the Court of Appeals reasoning in Cristobal, Ashcraft asserted that his jury engaged in speculation when it credited the inculpatory inferences from the evidence over the exculpatory ones. The Supreme Court rejected Ashcraft's argument, explaining that the fact that a court could identify an equally plausible alternative inference is not nearly enough to set a verdict aside. This is because the law is well established that the evidence of one or more alternate reasonable hypotheses does not necessarily prevent the jury from concluding the defendant is guilty beyond a reasonable doubt. Just because there is a reasonable alternate doesn't mean the jury can't find you guilty. Rather, the jury's exclusive providence is to weigh the competing theories of the case in light of the evidence presented and the reasonable inferences drawn therefrom, and to conclude which one they believe. The Supreme Court's holding in Ashcraft therefore necessarily overruled the very logic. See, this is an interesting argument. The jury's exclusive providence is to weigh the competing theories of the case in light of the evidence presented and the reasonable inferences drawn therefrom, and to conclude which one they believe. So they're literally saying you can find somebody guilty even if there is a possibility, a reasonable inference that could go a different direction. A lot of times we think that if there is another explanation that could also be true, the jury has to say not guilty, and the court says no, they can choose. The Supreme Court's holding in Ashcraft therefore necessarily overruled the very logic from Cristobal upon which the defendant now relies. The Court of Appeals also recognized, as our Supreme Court in Ashcraft has since clarified, quote, the fact that we can identify an equally plausible alternative inference is not nearly enough to set aside a verdict. And citing Wall, the Court of Appeals has repeatedly recognized that Ashcraft is a complete repudiation of Cristobal. Indeed, as this court's opinion of Wall made clear, we no longer view Cristobal's statement regarding equally plausible inferences as valid. That's a complete reversal of that held opinion. Defendant completely ignores Ashcraft and the Court of Appeals decisions recognizing Ashcraft's repudiation of Cristobal. In the existence of alternative inferences, if the existence of alternative inferences is not enough to justify setting aside a jury verdict of guilt, then it is certainly not enough to justify denying bindover at a preliminary hearing. Did I say repudiation? I'm cutting out the "ia." I'm pretty sure I said that wrong. The standard of proof is much lower at a preliminary hearing. A jury is free to pick and choose reasonable inferences in reaching its verdict. A preliminary hearing magistrate is not. The magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution. That's State v. Schmidt. At a preliminary hearing, the prosecution is not required to eliminate alternative inferences that could be drawn from the evidence in favor of the defense. Thus, viewing all reasonable inferences in the state's favor at a preliminary hearing is not speculation. It is precisely what the law requires this court to do. Defendant argument otherwise is based on overruled case law that he refuses to acknowledge and bring to this court's attention. And he quotes the defense memorandum, a couple of different sites. This blatant omission violates counsel's duty of candor to the court. This is candor to the court. There are some things that a lawyer is required to tell the judge. They're required to say. They're required, in all truthfulness, in candor, full candor here, I have to tell you this. The state is saying you... Some other choice. Marking me down. Troy, don't make me time you out. Just kidding. They're saying that the defense screwed up and did, this is like an ethical obligation that they have to do, candor to the court. A lawyer must not knowingly or recklessly fail to disclose to the tribunal legal authority in the controlling jurisdiction directly adverse to the position of the client and not disclosed by opposing counsel. They could get in trouble for this. Moreover, an inference is reasonable as opposed to speculative when it was based in evidence. As the Utah Supreme Court has acknowledged, there is no black line between inference and speculation, but a reasonable inference exists when there is at least a foundation in the evidence upon which the ultimate conclusion is based, while in the case of speculation, there is no underlying evidence to support the conclusion. So that's the difference between the two. Thus, a reasonable inference not amounting to speculation is a conclusion reached by considering other facts and deducing logical consequence from them. As the state's opening memorandum demonstrated, and is further detailed below, all the inferences the state has identified are grounded in the evidence. They are not speculative, and they support bindover on all counts. And now, when properly construed, this is part 2. Each argument gets broken down in more detail. So we summarized them. Now we've got each argument. So you're hearing a little bit of repetition here. When properly construed, the evidence demonstrates a reasonable belief that defendant knowingly created a great risk of death to another when he fired a high-powered rifle toward a crowd of thousands, including several who were in the line of fire or otherwise in close proximity to Mr. Kirk. Let me explain something. When you're at a firing range, a shooting range, where people with firearms sit in set positions or tables, shooting benches or in a little cubby, and they are preparing to fire downrange. No one is allowed to pick up a gun, period, If there is anyone, they can't even, usually you have to even stand back away from the firearms from the table. If there is anyone downrange, if there is anyone down there adjusting targets, putting new targets up, doing some maintenance, doesn't matter what it is. If they are one step in front of the line where all those shooters shoot from, nobody touches a firearm for safety reasons. You now have Mr. Robinson on top of the Losi building down there in Utah County with thousands of people between the end of his barrel and the target he's shooting at, many of them probably in sight in his scope while he is aiming. And his team tries to say, but everyone was back. I was just aiming at the one target. No one else was at risk. Let's see. When properly construed, we read that part. Just as he misrepresents the legal standard governing his preliminary hearing, defendant also misrepresents the standard for establishing the great risk of death aggravator. The existence of that aggravator does not require a minimum set of factual circumstances which must be present, as the defendant claims. Defendant's memorandum at 5, nor is the test a multi-factor analysis, as defendant also claims at 24. When the evidence is properly viewed under the test the Utah Supreme Court has actually endorsed, the evidence demonstrates a reasonable belief that the aggravating circumstance is satisfied here. A. Defendant misrepresents the applicable test for determining whether he knowingly created a great risk of death to another. In explaining and applying the great risk of death aggravator in State v. Sosa, the Utah Supreme Court expressly stated it was not establishing a multi-factor balancing test. Rather, the ultimate test is the statutory test, and that test requires that the defendant knowingly create the great risk of death. The three factors that Sosa court identified to guide the application of the statutory test are simply a range of factors of possible relevance to the statutory inquiry as elaborated in our case law. In fact, the court repeated, "We are not here to establishing a multi-factor test. The considerations in Sosa are non-exhaustive. They are not the test." The defendant ignores these portions of Sosa. That's terrible. Defendant also erroneously urges this court to construe the aggravating circumstance narrowly on pages 3 through 5. The legislature has already narrowed the aggravator by requiring that the defendant knowingly create a great risk of death to another. This court cannot apply its own narrowing gloss to that standard. Again, the ultimate test is the statutory test. Nor does defendant's emphasis on language from other cases, that the defendant must create a high probability of death, modify the statutory or standard. Defense's memorandum at 2 says, or that's where he says that, a high probability of death is just another way to say great risk of death. Other courts' use of the term high probability, therefore, does not modify the statutory test that Sosa endorsed. The ultimate test is the statutory test. I've got questions about this section. They're saying we want the language of Sosa to be the governing standard for applying this test. Ignore any other courts that addressed the same issue and use different language. I don't think that's the strongest argument. They're picking and choosing and ignoring other courts that might have come after that that dealt with the same issue. It also makes no difference that the facts of other cases do not precisely fit the facts here. Defendant spills much ink. Defendant spills much ink detailing the facts of other cases. 41 pages of ink of other cases where courts have analyzed the great risk of death aggravator. Many, many pages of that. But the fact that the other defendants did more to endanger others, like firing multiple shots, than the defendant did here is not persuasive. The issue is not whether another court has applied the aggravator in the case with identical or at least highly similar facts. Rather, the issue is whether the evidence, together with the reasonable inferences therefrom, when properly viewed in the light most favorable to the state, supports a reasonable belief that the defendant knowingly created a great risk of death to at least one other person. The ultimate test is the statutory test. They're repeating themselves. Much toner was spilled on this. The state has comfortably surmounted that low bar We stepped over that one, and it was easy, they say. This court must recognize that while Sosa analyzed and applied the great risk of death aggravator, it did so in a different context, and therefore had a different focus. Sosa fired 3 shots at 2 different people. He fired the third and fatal shot at his victim at close range, with his back to the other smoke shop employee. The issue in that case, therefore, concerned the scope of the relevant circumstances that a jury could consider in determining whether the aggravator was satisfied. As the court explained, the issue was whether the relevant circumstances extend beyond the precise act that caused the death of the victim, or whether the aggravator applied only where the murderous act itself creates a great risk of death to the third party. The court ultimately held that the relevant circumstances include more than just the murderous act itself. A person may be guilty of knowingly creating a great risk of death to another person if he did so within a brief span of time of the act causing the murder, and the acts together formed a concatenating series of events. Unlike Sosa, this case involves only the murderous act itself. The evidence supports a reasonable belief that the statutory test for the great risk of death factor is satisfied here. Although Sosa was focused on the scope of the relevant circumstances that can support an aggravator, its analysis is nevertheless helpful here because the Supreme Court recognized that firing a rifle at a murder victim while another is close by creates a great risk of death to that surviving person. As explained in the state's opening memo, Sosa Court recognized that there were 2 separate acts that created the great risk of death to the surviving smoke shop employee. The first act was a shot fired towards that surviving employee that missed. The other was a shot that hit the murder victim in the hand while the surviving employee was only a few feet away. Thus, contrary to defendant's contention, Utah has in fact adopted an interpretation of the aggravating factor that would permit its application where the firing of a single shot at an intended victim hit only the intended victim. Here, there were several people close to Mr. Kirk whom the defendant shot him dead. Most significantly, the questioner was directly between defendant and Mr. Kirk, and within a few feet of Mr. Kirk. There were also several people who were near the questioner. There were also those with Mr. Kirk who were under or near his tent. All these people were visible in the clear line of sight between the defendant's perch and Mr. Kirk's seat. Indeed, from a distance of 410 feet from Mr. Kirk, ballistics mathematics. Oh, we've got a prank call. Hold, please, hold on. Oh, they hung up. Never mind. I tried, guys. Okay. Basic mathematics. At a distance of 410 feet from Mr. Kirk, basic mathematics dictates that an angular shift of even 1/8 of an inch would result in a substantial miss of the intended target, either above, below, or to the right or left, depending on the direction of the shift, placing many others in danger. Given these facts, 2 of the 3 Sosa factors support the conclusion that the great risk of death aggravator applies. As explained, the spatial relationship between those in the line of fire or close to Mr. Kirk supports application of the aggravator. Okay, that's a cleaned up version. The defendant also threatened these people by indirect means through the risk of stray or ricocheting bullets. The other Sosa factor, the time between the murderous act and any other acts the defendant may have taken towards third parties, is simply inapplicable here. It's not a must meet all 3 of these. It's one of these factors must be considered. Consideration of the Sosa factors therefore supports the reasonable belief that the defendant knowingly created a great risk of death to those who were in the defendant's line of fire, and to those who were close to Mr. Kirk but outside the line of fire when the defendant pulled the trigger. The defendant knowingly created a great risk of death to those who were within his line of fire. Defendant attacks the state's line of fire argument, which he repeatedly mislabels as line of sight argument, on the basis that Mr. Kirk was seated in an elevated position. Defendant asserts that bullet traveled above, not through the crowd. But in State's Exhibit 8, the questioner's head is visible above Mr. Kirk's head. Others standing in the front rows of the crowd were positioned at approximately the same level as the questioner, but slightly further back from Mr. Kirk. And regardless of any precise elevation of the questioner's head and the heads of the others in the crowd in relation to Mr. Kirk's head, any difference is so negligible that it does not place these others outside the line of fire. The evidence therefore supports a reasonable belief that all these people were in the line of fire and therefore within the zone of danger that defendant created when he fired his rifle. Defendant knowingly created a great risk of death to people who were in his line of fire. A single fatal shot to the murder victim placed another individual who was in line of fire at grave risk of death. Part 2. Defendant knowingly created a great risk of death to those who were near Mr. Kirk when the defendant pulled the trigger. Defendant also knowingly created a great risk of death to those near Mr. Kirk, although not within the line of fire. 2 security personnel were directly in front of and on either side of Mr. Kirk, but still within the span of his tent. This is a pop-up tent. It's not a giant circus tent. Okay, this is a small space. A third security person was under the tent just to Mr. Kirk's right. This person had to only take a small step to reach Mr. Kirk as he fell. Another person was operating a camera just under the tent's front edge to Mr. Kirk's left. Defendant had a clear line of sight to view these people from just 410 feet away. The evidence also supports a reasonable inference that the defendant knew that people were in the area behind Mr. Kirk's tent. The defendant visited the amphitheater area at least twice before the shooting. This evidence supports a reasonable inference that he saw the staging area behind Mr. Kirk's tent. The fact that the defendant had a clear line of sight to Mr. Kirk's tent at the time of the shooting also supports a reasonable inference that the defendant knew people were in that staging area when he fired. Defendant argues that given the speed with which he had to acquire his target and fire once he got into position in the sniper's nest, the evidence does not support a reasonable inference that he knew that any of these people were present. But this argument again ignores the controlling evidentiary standard because it asks the court to view the inferences in defendant's favor rather than the state's. Defendant had a clear line of sight to Mr. Kirk, the crowd, those nearest Mr. Kirk, and those in the staging area behind the tent. The evidence therefore supports a reasonable inference that the defendant knew that all the above mentioned people were near Mr. Kirk when defendant fired his rifle, and defendant had longer than just approximately 35 to 45 seconds in the prone position to observe these people. He would have also seen these people as he ran and then crawled towards his rooftop position. Regardless, emphasizing how hastily defendant had to act to acquire his target and fire his rifle does not help him. It only highlights and increases the likelihood that he would miss his intended target. The speed with which the defendant had to act, coupled with evidence showing that he had to reassemble his rifle, that he loaded 4 cartridges in his rifle, and that in his early target practice he sometimes missed the target entirely, all supports the reasonable inference that defendant knew he could miss. That inference supports a reasonable belief that he knowingly created a great risk of death to both those in his line of fire and others near Mr. Kirk. Again, a jury can infer that an individual is knowingly engaging a person when that individual uses a gun in any area where he knows that others could be. Common sense also dictates that firing a gun, especially a high-powered rifle, towards others puts them at great risk of death. That is precisely why gun ranges prohibit shooters from even handling a firearm. This is my argument I told you earlier. I hadn't pre-read this. This is precisely why gun ranges prohibit shooters from even handling a firearm when others are downrange beyond the firing line. Provo Shooting Sports Park range safety rules at 2, item number 23, available at the Provo page right here. There's a website. We're not going to pull it up. And it was last visited August 17th, so this was 2 days ago. They pulled this off the website. Defendant highlights cases where other courts did not find the facts satisfied the great risk of death aggravator. Defendant's memorandum at 25 through 27 and number 13. But again, the issue is not how closely the facts here resemble those in other cases. The issue is whether the facts here, together with the reasonable inferences therefrom, demonstrate a reasonable belief that the defendant satisfied the statutory aggravator. And none of these cases resemble the scenario here. Moreover, some of these cases support application of the aggravating circumstance in this case. For example, although the defendant in Little John v. State, out of Oklahoma, fired only one shot in a convenience store that hit its intended victim, the court recognized that the aggravator applies when the defendant's acts create a risk of death to another, which are in close proximity, in terms of time, location, and intent to that act of the killing itself. There was no mention in Little John of how close others in the store were to the person who was shot and killed. Similarly, although the court in Johnson v. State found that the defendant did not create a great risk of death to another. Let me put the mouse back here behind me. There we go. To another person, let's see, when he fired the store manager at point blank range, the court also noted that no other person was within the immediate vicinity or within the line of fire, as is the case here. Finally, the court's statement in United States v. Bin Laden about a defendant who might carefully target his victim does not help defendant here. That court posited that a jury may find there to be a qualitative difference between the defendant who carefully targets an intended victim or victims without endangering others and one who acts with indifference to additional persons. But the defendant here acted with indifference to those in his line of fire and close to Mr. Kirk because his shot endangered them even though it ended up hitting its intended target. Part C. Many of the defendant's arguments depend on ignoring some evidence and improperly viewing the evidentiary inferences in his favor. Defendant's arguments that the evidence does not establish probable cause to satisfy the great risk of death aggravator are also unpersuasive because they ignore evidence and improperly view other evidence and reasonable inferences in the light most favorable to him. Defendant's argument that he did not have to reassemble his grandfather's rifle ignores the evidence that the rifle was in at least two pieces because he was both walking with a limp and carrying a backpack as he approached and climbed onto the roof. It also ignores the fact that defendants left a screwdriver on the roof near the railing that he flopped over to access the sniper's perch. Defendant omits the screwdriver on the roof from his recitation of the facts. And even if defendant could have concealed the entire rifle in his pant leg, transporting it that way supports a reasonable inference that the scope could not be in the same position that it occupied when the defendant sighted in the rifle, assuming that he did so before the shooting. This is significant for those that haven't shot a firearm before, and I wish I could show you, but YouTube doesn't allow me even to show like air rifles and stuff. But I'd like to show you the clamp, like a Weaver mount. The rail on a gun that a scope mounts on is basically it's shaped like this, like that. It has a little bulge on the side, and it's held on by clamps that attach to the scope on top. So here the scope is held on by rings, and then the clamp then screws on and it attaches outside that rail. And it looks like there's only one way it can go. Right, you just tighten down the screw and it grabs the rail and it locks on, but in actuality, a little slight movement of that ring on the scope or a tiny shift in how that grip, that little screwed ledge locks onto the track, can create massive differences in aim. So much so that people have spent a lot of money trying to design quick release latches for a gun that will force the scope to lock in exactly as it was before, because the normal ones, which Mr. Robinson's gun had, don't keep it the same. When you unscrew that scope and then screw it back down and tighten it on, it's different. The aim point, you have to re-sight it in. You have to fire a test shot. You have to make your adjustments to your windage and your elevation to get it right again. So, air rifle like an air guitar. No, I was going to show you like a pellet gun, which does not use an explosive charge to fire. It just uses compressed air. But even that YouTube does not like, so we can't show you. What I could do is I could make a video. I could film a video of me demonstrating, and then during a live I could play the video for you. How is that different, do you say? Well, YouTube is worried that if someone is filming and showing the handling of any sort of firearm live, that any accident might be caught and transmitted live to the viewing audience. Whereas if I were to film it first, presumably no accident would occur, and it would not suddenly be shown on YouTube for everyone to see. So anyway, that's it. Let's continue the reading, shall we? The targets found in defendant's apartment and the 4 engraved cartridges loaded in the rifle likewise support the reasonable inference that the defendant knew he might miss. Defendant's argument that the targets might be completely unrelated to the murder is undermined by their continued presence in his apartment and the discovery of a cartridge in his apartment that had the engraved words, "test shot." Oh, man. You can't make this up. And whether those targets are related to the murder or not, their presence in defendant's apartment supports a reasonable inference that they record his shots. The targets show that he seldom hit the bullseye and sometimes missed the target altogether. In sum, because the evidence demonstrates probable cause for each element of count 1, aggravated murder, the court must bind the defendant over for trial on that count. Section 3. Defendant's argument that he did not obstruct justice by directing his roommate to not talk to police improperly draws the inferences in his favor. Contrary to the defendant's assertion, his direction to Mr. Twiggs to not talk to police does not unequivocally demonstrate the defendant meant only to help Mr. Twiggs rather than obstruct an investigation. Defendant's argument otherwise improperly draws the inferences in his favor. Moreover, the defendant ignores that his direction to Mr. Twiggs about the police came in the same conversation in which the defendant also directed Mr. Twiggs to delete their incriminating text messages. The conversation also included defendant explaining how he concealed his rifle and changed his clothing. Although the defendant claims to contextualize his statement to Mr. Twiggs, he actually ignores the full context of his statement. Ignoring incriminating evidence does not make it go away. Ignoring incriminating evidence does not make it go away. Properly viewed, the evidence supports a reasonable inference that defendant intended to obstruct an investigation when he instructed Mr. Twiggs not to talk to police. The evidence therefore requires binding defendant over on count 6, witness tampering. Part 4. The evidence supports a reasonable inference that the defendant knew that at least one child was present when he shot Mr. Kirk. And Apprendi does not require the state to establish this aggravating factor or the victim targeting sentencing enhancement at this preliminary hearing. The evidence supports a reasonable inference that the defendant knew a child was present. Defendant's argument that there was no evidence from which this court can infer a reasonable belief that he knew a child was present focuses on only the short time the defendant was on the Losi building roof. Defendant ignores the evidence that he was in the amphitheater area at least twice in the morning of the shooting, including eating lunch at the Sorensen Center that borders the amphitheater. As explained, when all the evidence is considered, it supports a reasonable inference that the defendant saw the attendees that were gathering for the event, including the children who were present. But even if the evidence was limited to just the time the defendant was on the roof, he could see the entire crowd from that vantage point. The evidence alone supports a reasonable inference that he knew at least one child was present. The evidence therefore requires binding defendant over on count 7, committing a violent offense in the child's presence. Apprendi does not require the state to prove this aggravating factor or the victim targeting enhancement for counts 1 and 2 at the preliminary hearing. Defendant also misrepresents the holding of Apprendi in arguing that the state must establish probable cause at this preliminary hearing to support a violence offense in a child's presence aggravating factor for counts 1 and 2, and the victim targeting sentencing enhancement for those same counts. Contrary to the defendant's representation, Apprendi did not hold that any fact which increases the potential punishment in a case are elements or the offense which must be proven to a jury beyond a reasonable doubt. Rather, Apprendi held that any fact that increases the penalty for crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. Neither the violent offense in the child's presence aggravating factor nor the victim targeting enhancement implicate Apprendi because neither increases the penalty for counts 1 or 2 beyond the prescribed statutory minimum. The violent offense aggravator only requires the sentencing judge or the Board of Pardons on parole shall consider as an aggravating factor in their deliberations that the defendant committed the violent criminal offense in the presence of a child. It does not increase the statutory imposed maximum penalty for aggravated murder beyond death or the penalty for felony discharge of a firearm beyond 5 years to life in prison. So too for the victim targeting enhancement. Because counts 2 and 3 charge a capital and first-degree felony respectively, the victim targeting enhancement does not increase the level of those offenses or the statutory maximum punishment for those crimes. Rather, like the violent offense aggravator, the victim targeting enhancement requires only that the sentencing judge or the Board of Pardons and parole shall consider the defendant's selection of the victim or property as an aggravating factor. Because neither the aggravating factor nor the sentencing enhancement implicate Apprendi, the state is not required to prove their elements of this preliminary hearing. Rather, As explained in the state's opening memorandum, the state is required to prove the victim targeting enhancement only for count 7, committing a violent offense in the child's presence, because the enhancement raises that crime from a Class B to a Class A misdemeanor and therefore increases the statutory maximum penalty. So, now let's prove that. The evidence in Part 5. The evidence supports a reasonable inference that defendant targeted Mr. Kirk because of his perception. This is a different one. Because of his perception of Mr. Kirk's political expression. This is a tough one that was argued a lot. This is the Part K where they have like a whole list of things that can be used to as an aggravator or and a political expression is one of them. And defense is trying to argue that he did not pick a target based on his political expression. As with several other arguments, I need more water. Hang on one second. Let's see. As with several other arguments, defendant again ignores critical evidence in asserting that the state has not established probable cause to support the victim targeting enhancement to count 7. Most importantly, the defendant ignores that he engraved one of the cartridges in his grandfather's rifle with the overt political reference, "Hey fascist, catch." That alone is sufficient to establish a reasonable belief that the defendant targeted Mr. Kirk because of his perception of Mr. Kirk's political expression. Again, ignoring incriminating evidence does not make it go away. Defendant also ignores the evidence that as Turning Point USA's leader, Mr. Kirk's avowed purposes included promoting and debating political issues, and that his events on college campus were intended to further political ends. As explained, Mr. Kirk's goals included helping people develop the knowledge, skills, values, and motivation so they can meaningfully engage in their communities to restore traditional American values like patriotism, respect for life, liberty, family, and fiscal responsibility. Defendant further argues the evidence that to accomplish these aims, Mr. Kirk would hold events like the ones at UVU to discuss America's founding principles and political doctrines and to persuade attendees to follow a mindset rooted in politically conservative values. All this evidence, along with that discussed in the state's opening memorandum, establishes a strong inference that defendant targeted Mr. Kirk because of the defendant's perception of Mr. Kirk's political expression. This is especially true when this evidence is considered in the light of the defendant's admission that he killed Mr. Kirk because defendant had enough of Mr. Kirk's hatred. That's a quote. The evidence, therefore, establishes probable cause to support count 7 as an enhanced Class A misdemeanor, even if Apprendi applied to the victim targeting enhancement as to counts 1 and 2, which it does not. The evidence establishes probable cause to support the sentencing enhancement. The conclusion is, for these reasons, and those in the state's opening memorandum, the court should bind defendant over for trial on all counts charged in the information. And let's see, we've just got the service letters on the back. So just 14, 16, 17 pages or so of a filing. We got through it. We made it all the way to the end. What we're waiting for now in the trial of Tyler Robinson, the judge has to issue. I think he's written a written statement, response, ruling in the preliminary hearing. Remember, there was no grand jury indictment. Utah has the ability to do that. Rarely, if ever, does. And didn't in this case. A grand jury indictment would have skipped this preliminary hearing portion. They provide the same function. It's and you say that we look at grand juries and like, you guys would indict anybody. You'd indict a ham sandwich. It's the bar is that low. Equally, the bar is that low for the judge. It is every single possible inference has to be viewed at in the light most favorable to the state. And the bar is incredibly low. So yes, a grand jury does indict willy-nilly and with almost no evidence whatsoever, but that is what the bar is set at. That just means we're going to trial. So I think there's enough evidence here that the judge only has one option, and that is to indict. We do have... If for some reason something was not bound over in this, it would mean that the charge was misapplied. that there was, say, for instance, a drunk driving charge inserted in here that just doesn't fit the crime. And I don't think we have a misapplication of the charges. I think the charges that the state chose to bring are ones that the state could prove. I'm not saying the state has proven, but the state could prove in trial. And for that reason, I think it's going to be bound over on all the charged ham sandwiches have rights. Ham sandwich lovers unite. That reminds me. It's time for lunch. Almost. If you're here looking for the Tupac trial, which is going to be starting soon, it's actually going to be starting in a couple hours. It is 1 o'clock Eastern time at 4 o'clock Eastern time, which is this many hours away. We're going to start the trial. It is only a half day. We'll go from 4 to, they're going to go from 1 to 5. So we've got 4 hours potentially of evidence this afternoon. And looking at the schedule that the court sent me and all the media personnel on this, it looks like Wednesdays, this is a pattern we're going to have. Let me pull it up here just 1 second. Okay. So we've already done week 1. We had one short day. We're now on we've done the trial schedule. Sorry, I'm confusing the two. This is the Tupac schedule. I need food. That's what I need. I need food. I'm having a brain cramp moment. The trial schedule for Tupac, I'm trying not to think about Tyler Robinson, is as follows. We've done Tupac's week 1, the 10th through the 14th is done. We're now on week 2. 17th was Monday, 18th was Tuesday, 19th is 1 p.m. to 4 p.m., or 1 p.m. to 5 p.m. The 20th is also going to be 1 p.m. to 5 p.m., so today and tomorrow are half days. And then Friday we'll end with a 9 a.m. to 3:30 p.m. That's local times on all those. Gidge, member for 35 months, almost 3 years. You're about to get a new color courthouse, and it's beautiful. It's red. I'm saving it for you. You're going to love it. Thank you very much. But you're an OG. We'll have to talk about the mob testimony. So, yeah, week 2, we've got 2 short days, today and tomorrow, which is good. Tomorrow we do not have the podcast. That's a reminder. We're not doing the podcast tomorrow. And then a full day on Friday. Then week 3, because this is scheduled for 4 weeks. Week 3, we have full days Monday, Tuesday, Wednesday, and then a half day on Thursday and a full day on Friday. Week 4, full days Monday and Tuesday, half days Wednesday and Thursday, and a full day on Friday. So that's how it's scheduled. And it's sometimes we're starting at 9, sometimes at 9:30. There's a little bit of flux in there. But it's all good. Mob James' testimony was wild. It was nuts. It was crazy. If you missed yesterday, you have to, even if you're not going to follow the whole case, I suggest you go back and watch just the afternoon live stream, just the afternoon part, and watch the whole thing. And buckle up, and just it is nuts. It's wild. It's crazy. Some of the one-liners and comments back and forth, and things we observed, and words that were mouthed from one person to another. It was something else to see that. And as a matter of fact, there's a possibility that some of those are going to be addressed. Some of those issues, specifically the shaking of the head by Mr. Davis and the mouthing of the words, saying somebody was a trucking maggot or something, but there were more F's involved. That might be addressed by the court because a lot of people saw it. It's all over on Twitter. Yes, the Mob James also, Mr. James also laughed when asked a question on cross-examination. He's like, "You're serious? You're going to ask me that? You're going to get your client thrown in prison. You want me to answer that? I'm not going to say anything that's put him in prison. You're going to put him in prison by asking those questions." It was just a wild exchange, and he did hold true to his promise that he was going to be a hostile witness to both sides. It was good. Never seen anything like an exchange yesterday. The court behavior on the witness stand, we've seen some wild witnesses. I mean, look back to the Georgia trial that went for, what, a year and a half. The young thug, right? Look back, we've had some wild witnesses on the stand. We've seen that. What was really surprising to me was that after the witness was released and before he stood up and while the jury was still present, he basically looked to the judge and said, "I'd like to make a statement," and then proceeded to make a statement. And he apologized to various people in the room, and then he spoke directly to the defendant. And we're like, what is going on? I even said, object. You can't do this. But the judge allowed it. And yeah, you've got to watch out. All that happened from lunch on. So if you missed yesterday, now's a good time to catch it, for sure. The trial was a circus in Georgia. It was. Reggie Wright Jr. also cray-cray. It was. Having them back-to-back, James and Reggie back-to-back were pretty interesting. He had me laughing so hard. Favorite witness, for sure, so far of the trial. This dude, come get your lawyer. Oh, man. Never seen a judge allow that. She shouldn't have. And I don't know, is that an appealable issue? I wonder, I don't know, if they didn't object in the moment, if they've lost that. Might be appealable. I don't know. The judge let him. The judge didn't stop it. And to be fair, neither side objected that we could tell. So without an objection from either side, the judge sort of lets things go as just being a referee. Normally they step in and enforce some rules and decorum and order, but not then. Mob James' testimony was so wild it made the UK news. Yes, we have BBC. We've got Sky News from England over there. We've got a lot of big time global news channels that are following this case. I'm putting him in for best witness of the year. How do you do that, you may ask? Well, if only there were a form, Troy. If only there were a form a link you could click on. Oh, it's right there. You can make your nominations right there. Best and worst of. We use the best and worst of to provide some content for y'all and a place to hang out and reflect back on some of the things that happened over the year during the Christmas season. Because during those weeks around Christmas time, most courts do not want to seat a jury. Most juries do not want to be there. The judges are looking at getting, spending as little time as possible in court and as much time as possible with their families and allowing all jurors to do the same. So usually we don't have a lot to watch then, which gives us an opportunity to reflect back on the things that happened over the year. I just saw this as well, Judy. Judge says the judge in the Carmelo Anthony trial was removed and a new one will be appointed for Thursday's hearing. Yes. I think Kathy Russin had tweeted something about that. Yeah, it was Kathy Russin. That's a new development today. Judge Roach is recused from hearing any appeal efforts. A new judge will be appointed. Kathy got her finger on the heartbeat of everything true crime. Let's see. Just saw this video from Fox News yesterday. Waters off the coast of North Carolina were teeming with sharks on Saturday. This is a Fox Weather tweet. After a drone video captured what appears to be hundreds of sharks in shallow waters near the beach. Is it Shark Week? There's a bunch of them. A whole bunch. Man, I guess we have to not swim at the beach this weekend. I don't know why they're there. I guess they're looking for food. That's usually, they're either looking for food or looking for love. Those are the two reasons animals do just about anything. Lindsay, thank you. Thank you. I'm planning on submitting all mine. I've got notes when I'm on my recovery journey, something to keep me busy. That's awesome. Sloth Life, you're going to do great. Or, excuse me, Kill a Nap Time. You're going to do great. The Sound is teaming with orcas, so cool. Right, what's our plan going forward? Let me ask you what you would like to do. We could do a little more court hopping and take a late lunch, or possibly we might put together by we, I'm talking about me. I might put together a little highlights video from Mob James's testimony yesterday, and do that in this elongated lunch period where we have 3 hours to play back and show you some of the key moments, and we'll have that ready before we go live with the courts at 4 o'clock Eastern. What are your thoughts on that? I want the sound bites, I can tell you that. Come get your lawyer. Your lawyer's getting you thrown in jail. Tumwater Troy is the official mascot for court hopping. The bunny. That would be cool. I think we'll do that. I'll see if I can put that video together. Does that work? That gives us a long lunch. And I can portal us over to the afternoon session. So if you guys want to talk and hang out there while you're waiting, that will be open. It's open right now. But Amber has helped with the soundbite. She's given me some timestamps. Hopefully I can use them. We need a rap song. I'm thinking about that. I'm thinking. YouTube has changed the requirements on me when I use AI material, and what I have to disclose and report, and how I have to do it with every video. And it becomes very, very, very challenging to just, I can't just play music and say, oh, it's good, I'll go back and fix it in post. When was that testimony? I missed it. It was yesterday, Cass. It was yesterday, and it was something else. You'll see him because he's wearing a checkered shirt, black, white, and red. And he came in carrying a baseball hat, A's baseball hat. Did we talk about the Donna Adelson appeal? They filed the wrong documents. Oops. That's a whoopsies. Please delete my last email. Please don't publish any of the documents I sent. Those were supposed to be used internally with my team. They were not meant to be disclosed publicly. I will send you a new email with the proper appeal. That's funny. Finally seen the Plaid Guy testify. Couldn't help but laugh. It was good. Yeah, we do have all our songs right here if you want to listen to some of the songs we made before. Big deal. And everything else that's been published over there. What was the significance of the red checkered shirt? I believe it was he was a mob guy, right? Members of Bloods. It was his affiliation with gangs tended to be blood oriented. In my understanding, which is weird because you've got Bloods and Crips that cross the line, and Snoop was wearing blue, and it's nuts. It's crazy. I can't spit rhymes like that. My brain does not work that well. All right, we're gonna do a long lunch. It's decided, and that means I have to work. Is it mainly all circumstantial evidence? It's mainly self-tattling evidence in the Tupac trial. Dwayne Davis talked to reporters and talked for 2 books, and now wants to say, don't believe anything I said. That's what's up. All right, thank you very much. Oh, by the way, thank you, Love True Crimes. Did you see the blunder that Commonwealth made with the LC's mother-in-law? I've not. I've heard that there was a huge issue last night that could have been mistrial worthy. but I haven't heard how that happened today, so I have to catch up on that. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again 4 o'clock. So we'll be live probably 3:30 with Dwayne Davis out of Las Vegas. And then we're working late till 8 p.m. So mark it on calendars, move anything you need to, because it's just getting better and better with each day. Love you guys. We'll see you in a little bit. Have a great lunch. Bye-bye.
Because he's the guy.